said to me.
And I'm saying to me.
You didn't say to me, you just said it's not.
Okay, good morning, everybody. My name is Judge Kim Teresa Malika. I am your judge this morning. You're in first appearance court. Today is the day I will inform you of your charges, determine whether there is probable cause for those charges, and then determine whether you can be released from custody. Please understand that today is not your trial. You will not be found guilty or not guilty today. Since today is not your trial day, you do not need to comment on your arrest or the facts surrounding your arrest. You have the right to remain silent. You should use that right at all times. However, if you give up the right to remain silent, whatever you say about your arrest or the facts surrounding your arrest will be used against you. This hearing is being recorded. If you have a private attorney, please let me know that when you are called forward, okay? Because otherwise, we're going to have the public defender represent you unless it's a municipal ordinance case. All right, let's begin with the first case.
Your Honor, if we
Yes.
could just call one case at a turn.
Sure.
Damaris Fields, I believe he's on page 24. Just asking that case be set before Judge Cohen this morning.
Okay, is there a Damaris Fields there?
I know there's not a piece yet.
Good morning, Judge. There is.
Okay, counsel, please state your appearance for the record.
Sure. My name is Michael Farbarek with the Public Defender's Office.
Can you spell your last name for me, please?
Sure. It's F as in Frank, A-R, B as in boy, A-R-I-K.
And Brian Reedy from the Public Defender's Office.
Okay, and when Mr. Linder gets off the phone, we'll have him announce his appearance.
Eric Linder on behalf of the state, Your Honor.
Okay. All right. All right, so Mr. Fields is going to be taken over to Judge Cohen's division this morning?
I'll let them know, Judge.
Okay. Okay, the first case on the docket today is Nakia Smith. Okay, good morning, Ms. Smith. You're being charged with battery, causing bodily harm, domestic violence, state.
Your Honor, the state is going to be requesting a $2,500 bond in order of no victim contact. This is the third time out of Broward that Ms. Smith has been arrested for domestic violence battery.
What were the years previously?
She was previously arrested earlier this year, and that was dropped. And in 2012, and that was dropped. Those were both against a different alleged victim. I'm also showing that a different individual obtained a non-expiring injunction order of protection against Ms. Smith back in 2007. And, Your Honor, in 2009, she was convicted of a federal charge of fraud, sentenced to 2 years federal probation.
Okay. Mr. Reddy or Mr. Farberg?
Judge, I can tell the court that she's lived here all of her life, that she is separated. She has 3 children that are aged 10, 7, and 5. She currently works at Publix in the deli. She does have family members that live here. She did indicate she could afford a bond, not as much as the state's asking, but I would ask the court if the court would consider setting bond at $1,000.
Okay, thank you, sir.
And it also looks like this may be a situation of mutual combat, Your Honor, based on the probable cause affidavit.
Okay, the court's going to find probable cause. The court is going to set bond at $1,000. Ma'am, you are to have no contact, direct or indirect, with Haley Allen. Do you understand that, ma'am?
Yes.
Okay, and you're to surrender any firearms or ammunition to your local police department upon your release, ma'am. Do you understand that as well?
Yes.
Thank you very much. Have a good day.
Thank you, Judge.
All right, next one's going to be Jose Alexis Santiago Cosme. Okay, sir, state your name, please.
Jose Santiago.
Okay, Mr. Santiago, you're being charged with touch or strike battery, domestic violence. The court does find probable cause, state.
Your Honor,
And I also want it noted, there is someone here today in court.
can I just have one moment? That's who was the one that was the victim. There's no- Alright, well, there's no charge of one count, so- Your Honor, I don't have any criminal history.
Okay. All right, ma'am. Good morning, how are you?
How are you?
Okay, can you raise your right hand? Do you swear
Yes.
or affirm to tell the truth? Okay, you can put your hand down. Please state your first and last name and your relationship to Mr. Santiago Cosme.
Sure. My name is Claudia Zambrano, and I'm his current girlfriend.
Okay. Okay, defense? Would you like to hear from the victim first?
Well, I mean, I would point out that based on the probable cause affidavit, it appeared that nobody wants to prosecute this case. Nobody was willing to provide a statement. In fact, if Ms. Zambrano can confirm this, according to the police report, all parties signed waiver of prosecution documents.
Okay. All right, ma'am, what would you like to tell the court?
I just wanted to say that I'm not a victim in this particular case. There is a case hearing that was held yesterday against Juniores Ortiz Ayala, in which I was a victim of. In regards to this case against Mr. Santiago, I am not a victim.
Okay. All right, state or defense, anything further? We'll start with the state.
Judge, the only thing that I could add is that he's lived here for 7 years, that he has 2 children that are aged 8 and 3. He does work. He has actually a decent job. He has not a lot of money in the bank, and he does have family members that live here in the area.
Okay. All right, this is what the court's gonna do. The court is gonna put him on pretrial release. There's gonna be no contact, sir, direct or indirect, with the alleged victim, Juniores Ortiz Ayala, Ayala, in this case. And you're also to surrender any firearms or ammunition to your local police department upon your release. Do you understand, sir?
Yes, ma'am.
Okay, good luck to you, sir. Standard pretrial. 500 feet. Okay, thank you very much. Good luck to you, sir. Next one's gonna be Howard Warlick. Thank you, ma'am.
Thank you.
Howard Warlick.
Judge, I believe he's on medical loan. Oh, I'm sorry. That's what I get for guessing.
Okay. That's fine. Okay, touchers, Mr. Howard Warlick.
Yes.
Say that again.
Yes.
Okay, sir, you're charged with touch or strike battery, domestic violence. State?
The only thing I saw was a trespass in 2007.
Okay.
Yeah.
Department.
State anything further?
Your Honor, based on the level of violence, I would be requesting a $1,500 bond in order of no victim contact.
It appears again as though, it says, according to the report, Mr. Warwick was intoxicated. All parties refused to give statements, and the alleged victim in the case said she did not wish to pursue charges against Mr. Warwick.
Okay, Mr. Farborough, do you have anything further to add? I saw you talking to your client there.
Yeah, Judge, if I can have one more second.
Sure.
Judge, I can let the court know, he has several medical conditions. He was having trouble standing this morning. I believe he was out at the hospital. I'm not quite sure of how long he was there. He's been a resident here for 25 years. He also indicated, you don't have any priors, is that correct? He has no priors also, so I would just let the court know that. He is on disability based on the medical conditions that he has. So I don't know that he would be able to afford any bond at this time. I would ask the court, in light of the fact that he has no prior record, in light of the fact that he's on disability, if the court would consider RORing him.
Okay, the court's gonna ROR him, but put him on standard pretrial release. There's gonna be no contact, sir, direct or indirect, with the alleged victim in this case, whose name is Rosa Wade, and you're to surrender any firearms or ammunition to your local police department upon your release. Also, sir, a condition of your pretrial release is gonna be no alcohol or intoxicants, and you are to have random, test. Pardon? Yes. And random testing.
You're gonna get out to
And the court will waive the costs.
He's on standard supervision, though, right?
They don't, you can't do it?
No, actually, he's on standard supervision.
Yes, standard ROR. Okay? Okay, do you understand that, sir? All the conditions I just placed on you?
You understand?
Yes.
Okay,
Yes,
thank
ma'am.
you, sir. Good luck to you. Okay, next one. You're welcome. Next one's gonna be John Smoke. John M. Smoke.
Yes.
You guys over here?
Are you Mr. Smoke?
Yes.
Okay, we'll just wait for your attorney to get back, sir. Okay, Mr. Smoke, you're being charged with touch or strike battery. The court does find probable cause. State? Oh, we do? Okay, who is the interpreter for, Mr. Smoke, or the alleged?
Probably the victim, Judge, he speaks English.
Okay, Madam Interpreter, raise your right hand. Do you swear or affirm to tell the truth? I'm sorry, to translate from Spanish to English, English to Spanish.
I do. Alicia Stegmo.
Okay, and if you could translate for the person that's standing here, tell her to raise her right hand.
Alce su mano derecha.
Ma'am, do you swear or affirm to tell the truth?
Decir la verdad.
Lo juro.
I swear it.
Okay, put your hand down. Please state your first and last name and your relationship to Mr.
Y
Smoke.
relación con el señor Smoke.
Mi nombre es Gudiela Toro
My name is Gudiela Toro,
y John Smoke es mi esposo.
and John Smoke is my husband.
Okay. What would you like to tell the court today, ma'am?
¿Qué le gustaría decir
Oh,
a la jueza ahora?
I always do that, I'm sorry.
Señora.
He venido siendo agredida psicológicamente
I've
horrible
been here with a very strong psychological abuse,
y anoche
and last night
le reclamé porque
I
estaba
asked them
hablando con otras mujeres por el
why he
celular
was talking on the cell phone with other women,
y le quité el celular y le
and I
dije
took the
que
cell phone.
era evidencia para que vieran que él me
And
estaba
I
engañando
told him
horrible
that this was evidence that he was cheating on me,
y se lanzó a quitarme el
and
celular
he threw himself to take the cell phone away from me,
y me agredió
And he-
físicamente.
hit me physically.
Okay,
Okay.
so you're in fear of him, ma'am?
Así que usted le teme, señor.
Sí, es mejor
Yes.
que no quiero que se acerque
I don't want him
porque
to be
lo,
close to me.
Okay. All right,
Okay.
state?
I see no criminal history, Your Honor.
excuse me.
El Estado está diciendo de...
Noting the level of violence and the alleged victim's testimony before the court,
de la alegada víctima frente al juez.
the state would be seeking a $2,000 bond and an order of no victim
Una
contact.
orden de no contacto con la víctima.
If I may, Judge,
Absolutely.
and I'm not downplaying these allegations because we all know that they are very serious.
Porque son muy serias.
But when the state expresses concern about the level of violence in a misdemeanor battery,
por un delito menor de agresión, el nivel de violencia.
I would submit that the level of violence, in this case, you have to have some contact in order for it to be a battery at all. And this allegation is he slapped her and grabbed her. So, you know, I think if you're gonna make an argument that that's concern because of the level of violence, then every single battery charge is going to cause the state to express concern about the level of violence. And I appreciate what the young lady is saying, and I understand the court's concern, and I'm sure the court will be ordering a no-contact order. But I think in reference to bond, a small red mark was visible on her left cheek, is what the police report says.
Judge, I can also tell the court, just so the court knows, he's lived here all of his life. He has strong ties to the community, that he is married. He has 3 children. He works in real estate. He's been doing that for over 20 years, so he's had a very steady job as well. He has very little money, he said, in the bank. He does have family members that are here. He's indicated he's never failed to appear. The state indicated that there's no prior charges. I would ask the court, if the court's going to set a monetary bond, I would ask the court to set it at $1,000. He's not sure that he can post the $2,000 bond.
Okay.
Your Honor, I only feel the need to respond because Mr. Reedy brought my argument into question. I do have a concern when there's an allegation that a man slaps his wife in the face for no other reason than to recover a cell phone. And I can assure the court that I review each case on a case-by-case basis and do not make any argument that just applies to every single case as in general.
All right, thank you. All right, the court does find probable cause, if I didn't say that previously, for touch or strike battery, domestic violence. The court's gonna set bond at $1,000. The court is going to order no victim contact, direct or indirect, through social media or any other method with the alleged victim in this case, Godelia Toro Herrera. And sir, you're also to surrender any firearms or ammunition to your local police department upon your release if you possess any. Do you understand all the terms and conditions, sir?
Yes.
Okay, thank you very much. Good luck to you. And thank you, ma'am, for coming.
Thank you.
$1,000. I put it on there.
Judge, I think we might have another Spanish speaker in the main jail.
Okay, which one is this for?
What was this one? What was the name of this one? Excuse me?
Last name is Leon.
Okay, does anybody know where this is on the docket?
I don't know what it's
It's Leon. And while I'm going through this, are there any other Spanish-speaking ones I need to take out?
¿Alguien más que necesite intérprete en español?
He's on page 17.
How many pages are there?
There are 25,
Okay, I should.
so he's sort of toward the back of the docket.
Okay. Thank you. Okay, Ronnie Alberto?
Yes.
Okay. Okay, sir,
Señor,
okay, you're Ronnie Alberto Leon?
¿usted es Alberto Leon, Ronnie Alberto Leon?
Sí.
Yes.
Okay, sir, you're being charged with count 1, petty theft, second
Se
degree,
le
first
acusa
offense.
de robo menor,
Okay, count 2, petty theft, second degree, third subsequent offense.
y el segundo grado del segundo cargo es robo menor también.
And count 3, a capious felony.
Y cargo número 3, una orden de arresto por un delito mayor.
State,
Your Honor, he has a no bond hold on one of the counts.
Tiene una detención de no fianza en uno de los cargos.
Just requesting the standard
Estoy
bonds
pidiendo la fianza
kept in
estándar
place.
por los otros.
okay, the court does find
Que la
probable
jueza
cause.
haya motivo justificado.
Defense,
Defensa.
Judge, I would just ask that because he's got the no bond hold, he can't go anywhere anyway, so I would just ask that the bonds remain the same.
Okay, all right, so the court on count one is
Por el
25,
primer
count
cargo
two,
25,
750,
por el
and on
segundo
count three, the KPS
750
felony, no
y
bond
el
hold.
tercer cargo del delito mayor de orden de arresto, no fianza,
And sir,
detención sin fianza.
you have a status check,
Y usted tiene
in Division FG,
la
January
división
3rd at
FG
8:30 a.m.
el 3 de enero a las 8:30 tiene su
For
vista
your felony case. Good luck to you, sir.
para su caso penal.
Okay, thank you. Do you need me
Welcome.
to sign anything, Madam Interpreter?
No, thank you, Your Honor.
Okay, next one's gonna be Lee Benjamin Ashton.
Judge, he declined the public defender. He says he's going to hire private counsel.
Okay,
No, I was gonna talk to you about that. I mean,
Go ahead.
okay, are you Mr. Lee Benjamin Ashton?
yes.
Okay, sir, you're charged with touch or strike battery, domestic violence. The court does find probable cause. State.
No criminal history, Your Honor. State
Hold
would
on
be,
one moment, Mr. Linder.
So if I wanted to,
You want that? Okay. I'm sorry, Mr. Linder, go ahead. The clerk was talking to you.
he has no criminal history. State would be seeking a $1,500 bond based on the violence alleged and noting the alleged victim provided a sworn tape statement.
Okay. Defense?
Judge, he actually changed his mind. He indicated that he wanted to have a public defender.
Okay.
He indicated to me just now that he would not be able to, he may not be able to afford the $1,500. I don't know if the court would consider setting bond at $1,000.
Okay, Mr. Farberg, tell me something about your client with his work, ties to the community, etc.
Okay.
Ms. Patrice, is this for you?
No, these are the no contact orders.
Okay. That goes there, okay.
Judge, I can tell the court that he's lived here for 21 years, that he does have family members that live here. He indicated that he works doing homeowners insurance. He does have two children also. They're age 2 and 6 months old.
Okay. Okay, the court is going to ROR him, however, the court is gonna put him on standard pretrial release. The court is gonna order no contact, direct or indirect, with the victim in this case, Victoria Camille Davila, Divila. Sir, you're also to surrender any firearms or ammunition if you're in possession of any upon your release to your local police department. Do you understand those terms and conditions, sir?
yes.
Okay, thank you very much, sir. Good luck to you.
Thank you, Judge.
You're welcome. Okay, next one's gonna be Tobias Desmond Simpkins. Okay, Mr. Simpkins, you have a capias for a misdemeanor with the $5,000 bond. You're going for a status check in Division MV, which is gonna be reset in your division.
And Your Honor,
Yes.
state would request no contact order be issued. Name of the alleged victim is Elsie Simpkins,
Elsie, spell the first name,
Elsie.
spell the last name,
It's the
please.
same as his. Simpkins.
Okay, Simpkins?
Yes.
Okay,
I just feel compelled to point out for the record that this is a 2006 outstanding misdemeanor capias.
And it's also was court ordered.
Do you know when this is gonna be set in front of, Division MV? Okay, that's without prejudice for him to talk to his division judge, okay? Okay, Christova Spencer.
Let the judge has to say.
Okay, Ms. Spencer, you're being charged with petty theft, second degree, first offense. State?
She has no priors? I'm showing no history, Your Honor.
The property was recovered and she did cooperate with the police investigation, Your Honor.
Okay, so the court's gonna ROR her on this, okay?
Does she have an address? Now I remember why I pulled this aside. I'm looking at her booking.
None given, I see
She would not
that.
give an address when asked.
Okay. All right, in order for your client to be ROR'd, I need a street address, a mailing address.
Judge, what she indicated is the address she has written down in her personal items that were taken when she was arrested. If she can get the property, she can get the address. Pretrial should perhaps either be able to do it, or perhaps she can provide it to pretrial.
Okay, ROR, standard pretrial.
Well, Your Honor, even if she's placed on pretrial, I understand that Mr. Farbarik is saying pretrial can get that, and we have no problem with that. But we would then ask her to be standard pending verification.
Okay, standard pending verification.
Judge, I apologize. I didn't realize that I forgot it was a straight ROR. If the deputies or somebody can get her to her property, we can even reset it for this afternoon. And then that way she can come back with the address, and then she could be released ROR.
All right, let's reset this for this afternoon at 1:30, okay?
Thank you, Judge.
You're welcome. Okay, Maylin Dominguez Cortez. Ma'am, we're gonna reset your case to 1:30.
Your
Is
Honor,
there,
in the meantime, does she have a telephone number of Mr. Farbarik?
Mr. Farbarik?
Mike.
Does she have a phone number of someone we could call? If someone could post her $25
That's a
bond,
reset.
she would get out.
Oh, you're gonna
This
take it?
seems
Okay.
futile.
Okay.
I can find out.
Can you?
Yeah.
Because if we can make a call and someone says, okay, we're right down to post a $25 bond, then.
Okay, all right, next one's gonna be Maylin Dominguez Cortez.
She indicated everything is in property, the phone number that she would need to call somebody.
All right. She's
All right,
reset.
so what do we need to do? Do we need an order?
Reset her for this afternoon is what?
I asked the deputy if we need an order. He said that he can just do it. It would be okay.
All right, great, tell him I said thank you.
Right.
All right, so next person's gonna be, we gotta move along, Maylin Dominguez Cortez. Maylin Dominguez Cortez, where is she?
It says intake, it doesn't say main.
North Broward.
Okay, there. Okay, North Broward, do we have a Maylin Dominguez Cortez?
She's in transit, Your Honor. I don't have her here.
Okay, so then let's just, we'll pass this case. Okay, we'll put that one on recall. Then the next one's gonna be Jennifer Del Ishma.
Main jail, she's on her way up.
Okay. Okay, Jennifer Del Ishma.
Hello.
Hello, you have a Capias for a traffic $1,000 bond, state.
I see nothing on her driving record. She just has an ID card. That's,
Defense.
She indicated she's not going to be able to afford the $1,000 bond. She's been a resident here all of her life. She has a 5-year-old child. She recently completed her GED. She's not currently working yet, and that's why she can't afford the bond. I don't know if the court would consider either. Well, I would ask that she be ROR'd on this. I know the state indicated she had no prior.
this is the second time she's failed to appear on this case alone. I think Judge Hurley's bond of $1,000 is quite reasonable.
Okay, the court's gonna find probable cause based on failing to appear before Judge Hurley 2 times previously. The court is going to keep the bond at $1,000. Thank you, good luck to you, ma'am. Next one's gonna be Chiquita Nicole McFadden.
She's in North Broward, Your Honor.
Okay. Are you Miss McFadden?
Yes.
Okay, Miss McFadden, the court's gonna find probable cause. You're charged with count 1, grand theft between $300 and $5,000, and you have a probation violation or community control for a felony. State as to the grand theft.
Your Honor, based on the fact that she's on probation for grand theft, I'm just gonna ask that the $1,000 bond be kept in place.
Okay, defense? Mr. Reedy?
Yes, Judge, I spoke with Ms. McFadden. I explained to her that because of the bond, no bond hold on count 2, she's gonna have to wait until January 3rd to go in front of her division judge.
Okay, ma'am, on count 1, the court's gonna keep the bond at $1,000, and count 2, your probation violation, you're gonna be held no bond. You are gonna have for the VOP go in Division FG, which is on January 3rd, 2018 at 8:30 a.m. Good luck to you, ma'am.
Thank you.
You're welcome. Next one's Sheena Plummer. Sheena
Ms. Plummer is in Paul Ryan, Your Honor.
Okay. Are you Sheena Plummer?
Yes.
Okay,
Hold on,
ma'am.
Your Honor.
Pardon? Okay. Okay, ma'am, you are charged with 1 count of abuse of a child without great bodily harm, and count 2 probation violation or community control for felony. I can tell you there is a hearing in Division FD. What judge is that? Okay, in front of Judge Barbara Duffy on January 3rd, 2018 at 9 a.m. The court does find probable cause. State?
Your Honor, the state is gonna be requesting a $10,000 bond on count 1 and an order of no victim contact.
What is the victim's initials?
One moment, Judge. SH, noting that while Ms. Plummer is on probation for second-degree murder and noting that she was placed on 8 years probation after a 12-year prison sentence, the allegations are, and this is on a filed charge, that she struck a 4-year-old, causing visible bruising on both of the child's arms and a swollen left eye for, according to her own admission, because the child wet her bed and was jumping on the bed.
Anything further, State?
No, Judge.
Okay, defense?
As I explained to Ms. Plummer, Your Honor, she's being held no bond on her probation violation and is going to have to wait until the 3rd of January to go in front of Judge Duffy. I do think a $10,000 bond is excessive, however. I'd ask the court to set a $5,000 bond on Ms. Plummer.
Okay.
She's not going anywhere for the time being anyway.
I don't see how it could be excessive, Your Honor. She's on probation for killing someone, and she committed allegedly a felony-level offense involving violence against a 4-year-old.
Okay, the court has a concern for the community and the victim in this case. I am going to first order no contact, direct or indirect, with the alleged victim in this case. The initials again, sir?
Yes, SH.
SH?
Yes.
Okay, do you understand that, ma'am? You're to have no contact, direct or indirect, with the alleged victim in this case with the initials SH? Do you understand that, ma'am? Okay. All right, as to the abuse of child without great bodily harm, the court is gonna set the bond at $25,000. As to the probation violation or community control or a felony, the court, is gonna keep the no bond hold in place. Ma'am, you are gonna appear on January 3rd at 9 a.m. before Judge Duffy. Thank you very much and have a good day. Okay, next one is Jennifer Sarah Ware.
North Broward.
Okay. Jennifer Sarah Ware. Is that how you say your last name, ma'am?
Yes.
Okay. All right, the court is going to find probable cause for possession of PVP and count 2, grand theft between $300 and $5,000. State?
One moment, Your Honor. Your Honor, I'm going to be requesting that the standard bonds be kept in place. Ms. Ware's criminal history out of Broward, 2016, resisting without violence. 2015, possession of PVP and tampering with evidence. She was sentenced to 180 days in county jail. 2014, possession of cocaine and felony possession controlled substance, 180 days county jail. Out of the state of Pennsylvania, she was convicted of 2 counts of violating Pennsylvania's Drug Controlled Substance Drug Act. And, Your Honor, the only other thing I would note is that the grand theft charge in this case has been filed.
Okay.
Yes, Your Honor. Ms. Weir has been living here in Florida for 2 years. She's previously from Virginia. I'm sorry, how many?
6 years.
6. Oh, I'm sorry, I thought you told me 2. She's been living here for 6 years, Judge. She's been living in the same location for the last year with a friend. She was working as a bartender until a couple of months ago. She really has no one out there to afford a $2,000 bond to get her out. I know that this is a grand theft charge here, but it appears that the majority of her prior criminal history involves substance abuse. I think she might be a decent candidate for pretrial release if she has not demonstrated a history of failing to appear in the past, with a condition that she get a drug evaluation and start getting some help for her problem.
She did not want pretrial to contact the roommate to verify the address. We attempted to make contact with Carol Ware, with whom we left a voice message.
And I would note, Your Honor, Ms. Weir's been arrested twice for capiases, so Mr. Reedy's own words, I guess she wouldn't be a good candidate for pretrial release.
Well, that's not uncommon with people who have substance abuse problems, Judge, is that they don't prioritize things correctly. If we get Ms. Ware some assistance for her drug problem, then I think the chances of her returning to court are very good. And of course, if she doesn't, then a warrant gets issued for her arrest.
Mr. Reedy just said a minute ago, it seems she would be a good candidate if she doesn't have a history of prior failures to appear. Now she does, and now there's another explanation why she would still be a good candidate.
Well, the state points out how many times she's been arrested, but she's only failed to appear twice on all of those arrests.
Okay, the court finds probable cause for counts 1 and 2. The court's gonna keep the bonds at $1,000 each.
All right. Good luck, Jennifer.
Okay, I wanna go back to Sheena Plummer. Was that a Conti or Paul Ryan?
All right.
Okay, anybody, any deputy there, Paul Ryan?
I'll make her call you on. They probably took her to the unit. Yes, may I speak with the magistrate deputy, please?
Judge, also while we're waiting for Paul Ryan, Ms. Spencer we were able to obtain the address for her, so if you wanna recall her after Ms. Plummer.
Okay. Do you have the paperwork, Madam Clerk, for Spencer? Thank you. Okay. And Ms. Spencer is where?
She's here at main jail. Come on up. Judge, the deputy was able to obtain the address, which is 1053 Northwest 87th Avenue, Plantation, Florida 33322.
That's 1053?
That's correct.
Okay. All right, so we're gonna recall Christova Spencer. Okay, we're gonna ROR her, put her on standard pretrial pending verification.
Is there an apartment number?
Yeah,
They didn't-
RORs,
The deputy didn't write it down. I do have a number for contact. The person she's staying with is Claudette Wellington.
okay.
The phone number is 954-274-9783.
Okay, this is what the court's gonna do. The court's just gonna straight ROR her, okay?
Your Honor, I can tell you right now,
Hey, thanks.
even with that information, court notice is not gonna be deliverable, because from what I can tell, there are apartment numbers.
Okay, this is what the court's gonna do. The court's gonna ROR her, put her on pretrial pending verification. There's just too many questions going on about where she resides, so this way we can keep tabs on Miss Spencer, okay?
Thank you, Judge.
You're welcome. Okay. Let me know when Miss Sheena Plumber's back, please. I did, I have it on the, okay, Ms. Plummer, the reason why I called you back is I wanted to also order no contact, direct, or with any minors under 12 years of age or younger, unless you are supervised by an adult. Do you understand that, ma'am? Yes? Okay. And state also, I'm assuming that you're going to contact DCF,
Well,
or have they been contacted already?
since it's a file charge, I imagine they already have.
Okay, I just wanted to make sure.
Sure.
Okay, thank you, ma'am. Good luck to you. Okay, next one is gonna be Ashley Chantel Henderson.
Main jail.
Okay, Ms. Henderson, the court does find probable cause. You're charged with count 1, false ID given to a Leo. Count 2, capious felony. Count 3, capious felony. You do have a status check in Division FP on January 2nd at 9 a.m. and also a status check in Division FN as in Nancy, on January 3rd at 2 p.m., ma'am. State? We're on Ashley Henderson.
Your Honor, with the no bond holds on 2 and 3, I'm just asking that the $100 bond be kept in place.
Okay, defense? Same?
No objection to that.
Okay, so then on count 1, $100 bond. Count 2 and 3, court's gonna keep the no bond hold. Thank you very much. Yes. There is one corrected on count 3, 17-001887 CF10A. Thank you. Okay, next one's gonna be Tricia Serrao, Serrao.
North Broward.
North Broward.
Okay, are you Miss Sarah?
Yes, ma'am.
Okay, did I say your last name right?
Sorrel.
Saro, okay. All right, ma'am, your charge will count one, possession of methamphetamine. The court is gonna find probable cause. State.
2015, she had possession of PVP, which she violated her probation on. And also,
2009? Why not she have something Broward in 2009?
I don't see it here.
2009, she had a grand theft with a violation of probation. Actually, she didn't violate probation on the possession of PVP. She was just sentenced to 364 days. The probation she violated was on the 09 grand theft. See that?
Okay, what's your recommendation as to bond and any restrictions?
Your Honor, I'm asking that the $1,000 bond be kept in place. I'm also showing she's had prior arrests for failure to appear. I see one, keep going, one, two, keep going.
Your Honor, that was a long time ago.
Don't say anything, Tricia.
She's had a,
She has something out of Pennsylvania right now.
So she has an out-of-state hold.
It's not a
So-
hold on her, but it does show that there was an open charge in Pennsylvania. She attempted to post her bond, and when the bond agent recognized that she had that pending in Pennsylvania, he brought the bond back. So now they have to find another bond agent here.
just FBI.
Sure.
Actually, she does have a warrant, Your Honor. Issued out of the state of Pennsylvania, issued June 13th of this year for her failure to appear.
And that's why the bond agent, he brought the
But
bond.
they're not expeditable.
Your Honor, the bond agent
Not really the point.
brought it in and saw that hold, and then he came back and took his.
Okay, so state, what's your recommendation?
Your Honor, in light of the allegations, I'm still fine with the $1,000 standard bond, but I do believe it is appropriate. And she has also gone to state prison out of the past, out of Lee County, Collier County, grand thefts, uttering forged instrument, fraudulent use of personal identification information, possession of cocaine.
Okay, defense?
Your Honor, Ms. Sarro has been living here in Florida for 10 years. She's married. She has 3 children, ages 7, 10, and 17. She has been living in the same location for the past 4 years. She has her GED. Her husband is a tow truck driver. He's had the same job for 23 years. She has provided me with his name and number to try and see if they can raise bond. She indicates to me that a $1,000 bond might be out of their reach at this particular point in time. I'd ask the court to consider a lesser bond for Ms. Sarro.
Okay,
I don't see how a $1,000 bond could be out of the reach when they had enough to go to a bondsman. He just chose not to post it.
Yeah, we don't have collateral. We don't have any collateral.
okay, hold on, ma'am. Okay,
Ms.
the court-
Sarro indicated to me that they also do not have any collateral, and that might be a problem for a bond being posted as well.
The bondsman was on the way. His issue was her out-of-state issues, not a collateral issue.
Okay, the court found probable cause. The court is going to keep the bond at $1,000 on count one. Thank you very much, ma'am. Next case is gonna be Chinese Brian Kendrick.
Main jail. Mr. Kendrick? She's on her way up.
Okay. Okay, I'll do that one next, okay? Thank you. Okay, are you Chinese Brian Kendrick?
Yes.
Okay, good morning. You're being charged count one, petty theft, first degree. Count two, fraud, utter a false instrument. Count 3 and 4 are probation violations for community control for felony cases. You have a VOP hearing in Division FC on January 10th at 8:30 a.m. State?
Your Honor, in light of the VOP holds, I'm requesting that the standard bonds on 1 and 2 be kept in place.
Okay.
No
Defense?
objection to that, Judge.
Okay, so on count one, it's
Anyway, so.
ROR, count 2, $1,000, and count 3 and 4 is a no bond hold. Okay, thank you very much. Next one is Maylin Dominguez Cortez. That's in North Broward,
I believe that's where she has been found, Judge.
Okay. you Maylin Dominguez Cortez?
Yes.
Okay, ma'am, the court does find probable cause. You're being charged with count 1, disorderly intox, count 2, resisting an officer without violence, and count 3, trespass or failure to leave property by order by owner. State,
I see no criminal history, Your Honor.
what kind of criminal history?
No, I see no criminal history.
Oh, no criminal history, okay.
Judge, I'd consider, I mean, I haven't had a chance to talk to Ms. Dominguez Cortez because she was in transit, but I'd ask the court to consider an ROR if she has no prior criminal history.
Okay, so then on counts 1, 2, and 3, the court is going to ROR Ms. Maylin Dominguez Cortez. Also, ma'am, you are not to return to the banned shell located on the boardwalk of 1111 North Ocean Drive in Hollywood, Florida. You are to maintain 500 feet from that place at all times. Do you understand, ma'am?
Yes.
Okay, thank you, ma'am. Have a good day.
Thank you.
Next one is, next one is Christine Cynthia Cruz. Okay, ma'am, state your name.
Christine Cynthia Cruz.
Okay, ma'am, the court does find probable cause. You're charged with 1 count of grand theft, and 1 second count is grand theft auto. State?
Your Honor, Ms. Cruz has a warrant out of the state of Virginia
Okay.
for failure to appear in October of 2014 on a domestic violence assault. I'm also showing, I'm showing she has 2 open felonies out of Palm Beach County, one from this year, one from last year. The case from this year is burglary of a structure, grand theft, and fraudulent use of a credit card. Last year, it is grand theft from a dwelling. She has another felony open in Palm Beach, attempt to commit robbery from last year. And that's all I see, Your Honor. Based on the fact that she has 3 open felonies for similar offenses out of Palm Beach County and an active warrant for her failure to appear, I'm requesting the bonds on each count be raised to $2,500 for a total bond of $5,000.
Okay, defense?
Ms. Cruz had indicated to me that she believed her mother would be able to assist her in bonding out on the $2,000 bond level. I didn't ask her about $5,000. Do you think your mother can make a $5,000 bond, Christine?
No.
Then I'd ask the court to leave the bonds where they are.
And that would mean basically ignoring the fact that she has 3 open felony cases in Palm Beach for no other reason that she's standing before the court telling the court she can't afford any higher bond.
No, because I'm going to court for those because I'm a
Okay.
CI for them.
Okay, hold on, ma'am.
Don't talk about that.
Well,
Ma'am, don't talk about the facts of your case. The court's gonna find probable cause on the grand theft, count 1, and the grand theft auto, count 2. The court is gonna raise the bond to $2,500 based on an active warrant out of, did you say Virginia or West Virginia?
Virginia.
Okay, out of Virginia. Ma'am, just hold on, and there are open cases. This was that without prejudice to go to your division judge and ask for a bond reduction. I also am gonna order no contact, direct or indirect, with the alleged victim in this case, Mark Moss. Do you understand that, ma'am?
yes.
Okay, thank you very much. Have a good day. Good luck to you.
So they raised my bond?
Yes, I'll call your mother and see what she can do.
She can't. My mother is poor.
Okay.
Deputy.
Which one?
She's pending verification.
We're done with the case, Deputy. Just so-
Okay, hold on one moment. Ma'am, your bond is set at $2,500 each. The public defender's office will have someone come over and talk to you. Have a good day.
Because if she's ROR, she's gonna get out.
Okay.
Just to clarify.
So what would you like me to do?
I would like for the court to write the bond back of $25, and then just leave it pending verification. And then you leave the words pending verification on there, and we're good to go.
Okay, did you hear that, defense?
Not all of it.
Okay, on Christova Spencer,
Yes.
pretrial, Ms. Patrice is telling me that with the petty theft charge, we can't do an ROR pending verification. Because if we do,
What
then
happens
she'll
is
be released.
We leave bonds in place until they are verified, as I'm sure you're aware. Then after they're aware, so we're just, the court had tossed the bond out, I'm just asking her to write it back.
case she can't get out.
Correct.
have a complete address for her.
I have
You
one
have it?
too,
Okay.
I do, thank you so much.
Here, I wrote it in here for
Yes,
you.
right, you can give it to me.
Okay.
Thank you.
All right, so we'll change the bond from ROR to $25. Thank you for clarifying. Okay, Jessica Lane.
Yes.
Okay, Ms. Lane, the court does find probable cause. You're charged with count 1, possession of cocaine. Count 2, possession of heroin. Count 3, possession of alprazolam, which is also known as Xanax. Count 4, possession of cannabis, 20 grams or less. And count 5 is a civil traffic infraction for disobey a stop or a yield sign. State?
Your Honor, I'm just showing a prior theft and resisting without violence from a couple years ago.
Okay, what's your recommendation on bonds?
I'm not asking for a bond increase. I imagine Mr. Reedy will have more information seeking alternative
Okay,
release.
Mr. Reedy?
Yes, Your Honor. Ms. Lane has been living in Florida for the last 21 years. She does have family here, including her mother. She has 2 jobs. She works as a cosmetologist. She's been doing that for about a year. She's also been working as a waitress for the last 2 or 3 months, and from what she tells me, she's doing well right now. She's been living in the same residence for the last 21 years with her mother, and that's where she would be living if she was released. As Mr. Lender points out, her criminal history is rather minimal. She's a high school graduate. She graduated from high school in 2014. She was able to provide me with the names and phone numbers of both her mother and her grandmother. The problem is that right now her mother is in Israel and is unable to assist her in posting the bond. In light of her strong ties to the community, relatively a little criminal record, I'd ask the court to consider pretrial release for Ms. Lane with a condition, as she even asked for this, that she gets a drug evaluation and a treatment.
No, it does appear she had some money. According to her admission, she went to the residence to purchase heroin.
It wasn't for me.
Don't say anything about the facts of your case, Ms. Lane.
Okay, so Mr. Reedy, your suggestion as to bonds?
I'd ask you to ROR, Judge, to pretrial release. She cooperated fully with the investigation, gave a statement to the police to respond to Mr. Lender's indication that because she had these drugs on her, she must have money. She indicated that the person who provided her with the cocaine and Xanax gave it to her on the house. And, sometimes people spend their last bit of money that they have on drugs when they have these kinds of issues.
Just to be clear, I didn't say because she had the drugs she had money. I said she must have some money because she made an admission that she went there to buy the drugs. And apparently, well, I'll leave it at that, but all right.
Okay, this is what the court's gonna do. As to count 1, the court is going to lower the bond to $100. As to count 2, the court's gonna keep the bond at $1,000. As to count 3, the possession of alprazolam, the court is gonna keep the bond at $1,000. And count 4, the court's gonna hold the bond at $100. Thank you very much, ma'am. Good luck to you. Okay, next one's Ronnie Lynn Nieto. Ronnie Lynn Nieto. Oh, okay, I'm sorry.
Does she have anything?
intoxicated. I don't know if somebody's posted her bond or is working on it. I don't know if they can check to see if it's been posted yet.
Okay, the court does find probable cause, Ms. Nieto, for one count of possession of cocaine. Does anybody know if her bond's been posted for 1,000? Thank you. Okay, sir, Mr. Forborick, it doesn't show that it's been posted yet, according to the confinement status.
Okay, Judge, no. Judge, I can tell the court that she's lived here all of her life, that she has been divorced for a period of time. She has no money in the bank and she's currently not working. However, she does have family members here in the area. I am not sure, but I don't believe she has a prior record.
No.
She has no prior record.
Okay, state.
Has not yet been posted, but we did speak with someone who told us that they contacted the bond agent and is posting her bond.
Did you hear that, Mr. Forborick?
I did not, Judge.
Okay, Ms. Patrice, if you could speak again. so that
Mike,
we-
somebody's posting her bond. They contacted the bond agent.
They're in the process of it?
It would appear so.
That's what they told us.
It appears that way.
If I can have 1 second, Judge.
While Mr. Farberic's talking to her, I'd also point out, Judge, this looks like a residue case, which probably will end up as filed as a possession of drug paraphernalia charge.
State, what's your position as to that?
Well, we're not here in a filing stage, we're here in a bond for bond purposes, and people don't sell residue. I imagine if she had residue, it was in a different form at some other point.
I think the allegation is possession of cocaine, not selling anything.
Well, if we're talking legal, then the case law is clear. You can be convicted of possession of cocaine even with residue.
Yes, I agree, but my understanding is the state attorney's office is going to be filing these charges as misdemeanor possession of drug paraphernalia charges, and that is what this case is. So I think the court can certainly take into account the fact that this case may not be filed as a felony at all in determining what the appropriate ruling should be in Ms. Nieto's case.
And clearly, the court can also take into consideration that
If you
she
could talk a little
believes
bit
someone's
louder,
supposed.
Mr. Linder.
I'm sorry?
If you could talk a little bit louder
Sorry.
with the feedback.
Then the
it's
court,
hard
I would
for
say
me
the
to
court
hear
could
you.
also take into consideration, she's under the impression someone's posting her bond, and that same person or somebody informed pretrial, they're in the process of contacting a bondsman to
Okay,
post the
court
bond.
finds probable cause, the court's gonna leave the bond at $1,000. Thank you. Good luck to you, ma'am. Okay, next one's going to be Cynthia Brandon.
She's in North Broward, Judge.
Okay, are you Miss Brandon?
Yes.
This,
Okay, good morning, ma'am.
Good morning.
this is a change of charge, Your Honor. On the change of charge on the female docket. Your Honor, Judge Canner, this is a filed case. Judge Canner originally set her bond at $500, finding PC for trespass. We have filed it as attempted burglary. I provided the original probable cause affidavit and an additional report because there's additional information that wasn't contained in the probable cause affidavit that I believe would have resulted in a finding of probable cause for attempted burglary. Specifically, the allegation that Your Honor, in the original probable cause affidavit, it is mentioned that, it just mentions that Ms. Brandon attempted to enter the dwelling. It doesn't give any specifications. In the supplemental report, the witness observed her tearing or using something to tear the screen in the door, and then the door had been tampered with. The officer goes into details about how the door was tampered with. That being said, even though it has been upfiled from the charge that Judge Kenner found probable cause for, I'm still asking that the $500 bond be kept in place, which I think is more than reasonable bond for an attempted burglary of a dwelling.
Ms. Brandon has indicated to me, Your Honor, that she's unable to post any kind of monetary bond whatsoever. Her son is currently in the hospital, and she would like very much to see him. He's 19 years old. He's been in the hospital since October 24th. She's been living in the same address. Well, she lived at the same address from March to September. She's now staying in a shelter. She's told me she has $100, and she also indicated to me that she has no prior criminal history.
And Your Honor, I would also know, and I just remember this when Mr. Reedy brought up the subject of children, the allegations are that she also brought 2 minor children to this location where she allegedly attempted to commit the burglary.
I mean, I'd ask the court for $100 bond.
Yeah, we're trying to break into a home.
Sorry, Mr. Linder?
All I can say is $500 for allegedly attempting to break into a home, a 3rd-degree felony. I think that's more than reasonable. Judge Kenner found it to be reasonable when he was only finding PC for trespass. And he was aware. I remember the first appearance. He was aware of her financial situation, that her condition was brought to the judge's attention, and he still determined a $500 bond was appropriate.
Okay, so the court's gonna find probable cause for the change of charge, attempted burglary of a dwelling, is that correct?
Yes.
Okay, and the court is gonna keep the bond at $500. Good luck to you, ma'am. And there's also an order, ma'am?
She was already, just so you know, she was already ordered to stay away from the resident.
Okay, that's what I was gonna say.
Yeah, I figured.
Remember, ma'am, there's an order for you to stay away from the residence as well. Good luck to you, ma'am.
Thank you.
You're welcome. Next one's gonna be Scott Everett Penny.
Judge, he's a little bit hard of hearing. If everybody could kind of speak into the microphone so he can hear a little bit better.
Okay. Are you Scott Everett Penny?
I can't hear what you're saying.
Can you hear anything? You can't hear anything?
No. I read your lips.
Can you read her lips on the video?
No.
Do you read sign language at all? Sign language at all?
No.
Judge, I can relay the information.
Okay, are you Mr. Scott Everett Penny?
Are you Mr. Scott Everett Penny?
Yes.
Okay, sir, the court's gonna find probable cause for standing in the road.
The court's finding probable cause for you standing in the road.
Count 1,
The road, count 1, they
And
find
ca-
probable cause.
okay, and count,
For what? Hold on, just listen to me, okay?
and also count 2, capious misdemeanor.
You also have a capious misdemeanor petty theft that I told you about before.
Okay, state.
That's all I have.
Your Honor, Your Honor, I'm going to ask that the $1,000 bond be kept in place, only because I can tell you, in the case before the court, the state has actually previously filed a motion to revoke Mr. Penny's pretrial release. He then apparently failed to appear in court, and the basis for the revocation motion was that while Mr. Penny was on pretrial release on this case, he was arrested for committing a new petty theft.
Okay,
Can I have a second to translate it, Judge?
sure.
Judge, he indicated that, basically he was not in Hollywood. I think that's where this event occurred. I don't think he's understanding that, they were trying to revoke the bond. I tried to explain it to him, but I don't think he understood that part.
Just to be clear, I'm not asking the court to revoke any bond or release at this time. I'm just advising why I'm asking the $1,000 bond be kept in place and not making an offer, because it appears there's going to be a motion to revoke filed that's been prepared already. Just to be clear.
Okay, let me convey that, please.
Sure.
Judge, I've explained to him that the state is asking for a $1,000 bond on this case at the present time. He indicated he has no money. He's lived here for 13 years. that he is on disability, he receives a little over $700 a month, and that he's on food stamps. I would just argue on his behalf that he wouldn't be able to afford a $1,000 bond. I would ask the court to set something a little less than that.
Just noting, and I didn't come up with that number arbitrarily. That's the bond that Judge Hurley set when he failed to appear in court.
Can I get an ROI so I don't lose my disability?
I think the court heard that.
When is his case set before Judge Hurley?
They can't set it before Judge Hurley because if he's in custody, they can't bring him to North Satellite. But
I understand.
his other theft that the alleged theft that would violate his release conditions is set before Judge Pohl.
Because he's in custody, yeah. So when is he gonna be before Judge Pohl?
They issued a summons on that case, but now that he can actually be brought before Judge Pohl for arraignment now that if he's in custody.
Okay, all right, so this is what the court's gonna do. On count two, the court's gonna keep the bond at $1,000. Thank you, sir, good luck to you. Next one's gonna be Christopher
Thank you, Judge.
Caraciola, you're welcome. Joseph Christopher Caraciola. Okay, are you Mr. Caraciola?
We need the on.
Sorry.
That's okay. All right, Mr. Caraciola, the court does find probable cause. You have a capias for misdemeanor. I believe it's for possession of cannabis. Is that right, State?
Yes, it is, Your Honor. And if Mr. Caracioli wishes to resolve this case, the state's offer would be a withhold, court cost, and judicial notice of time served.
Okay, what's the court cost, Madam Clerk, on a marijuana charge?
I don't know what that means, but the case
What are
would
the
be
court
open.
costs on a possession of marijuana under 20 grams?
Charge, your conviction on your record, so you would basically.
308.
I'm sorry, would be, you'd have to pay court costs. Oh, okay. You wanna do that? Yeah. Judge, he wishes to resolve the case.
Okay, sir, raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, put your hand down. State your first and last name.
Joseph Craxioli?
Is that Caraccioli, sir, for your last name?
Yes, ma'am.
Okay, sir, you're being charged with possession of cannabis under 20 grams. Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Do you understand the proceedings today, what's going on here?
Yes, ma'am.
Okay, are you pleading guilty or no contest to possession of marijuana?
Guilty is fine.
Okay, and you want to give up your right to a trial, sir?
To what?
You want to give up your right to a trial?
Yeah.
And plead no contest? Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. Court's going to give you a withhold of adjudication, take judicial notice of how many days in the Broward County Jail, 2? Okay. And the court's going to give you a withhold, court cost of $308. Counselor, how much time does your client need to pay?
How long do you think you need?
6 months, 1 year?
Get a family member.
6 months, Judge.
Okay, the court's going to give him 6 months to pay the $308 in court costs.
Thank you, Judge.
Thank you. Good luck to you, sir. You have 30 days to appeal the sentence of the court, okay? Next one's going to be Kelsey Montel Williams. Okay, please state your name, sir.
Chelsea Williams.
Okay, Mr. Williams, the court's going to find probable cause. Your charge count 1, petty theft, less than $300, and count 2, criminal attempt to solicit or conspire, which is a first-degree misdemeanor, State.
Your Honor, I'm not gonna be able to make an offer to Mr. Williams at this time. We had his co-defendant, Shanice Kendrick, earlier, and while I understand he's been charged with attempt or solicitor conspiracy, and there's PC for that, I also believe, based on further investigation on what the allegations are, is that Mr. Williams could also potentially be charged as a principal to uttering a forged instrument, and that, according to the allegations, he is the one that provided the forged and stolen check to Ms. Kendrick for the purposes of her, on his behalf, attempting to cash it.
This is a check cashing store case?
Yes, it is.
Okay.
and she actually made reference in her report that she was given by a man, she was given the check and asked to cash in his behalf.
Okay, so it's to count one?
Your Honor, I'm fine with the 100 on count one. On count two, I'd be asking for the same bond that Ms. Kendrick received for uttering a forged instrument, which was $1,000. In 2015, Mr. Williams was convicted of violating a domestic violence injunction.
Okay, that's it?
That's all I see.
Okay. Defense?
Judge, he did want to try to work this out, but if the state's unable to make an offer, I can tell this court that he's lived here for 25 years, that he has no money in the bank. He occasionally will work labor pool when he can. I asked him if he would be able to afford the $100. He indicated that he probably would not be able to afford that. I would ask the court to consider RORing him. If the court is not inclined to do that, I would ask him to be placed on pretrial release.
Standard pretrial?
Yes, Judge.
Okay, this is what the court's gonna do on count one. The court's gonna keep the bond at $100. At count two, the court's gonna keep the bond at, change the bond to $25 and do standard pretrial release. Or you know what? I don't have to do the 25 because it's not pending verification, so I can ROR.
So it's bond plus pretrial.
Yes. Okay, thank you very much, sir. Good luck to you.
Suggest that the court does not ROR count two and just leave it and put both counts on one count.
Sure. Okay, I put both counts, Patrice, standard pretrial release, okay? Thank you. Okay, next one's gonna be Elijah Lamont Hamilton. You, Mr. Hamilton? Okay, sir, court does find probable cause. You're charged with count one, resisting an officer, obstructing without violence. Count two, trespass property, not a structure or conveyance. State.
Your Honor, if Mr. Hamilton wants to resolve the case, the state's offer would be an adjudication, time served, no return to the listed property, 725 Northwest 14th Terrace. I would advise the court, and just so Mr. Farbarik's aware, Mr. Hamilton has pending felonies, attempted strong-arm robbery, battery on a victim over the age of 65, and unlawful use of false name identity.
Okay, the court's not gonna resolve this case today, so your suggestion as to bond?
Your Honor, in light of the fact that he is an open felony involving violence, I'd ask that the $100 bond be kept in place.
Okay, defense?
Judge, we have no objection to the $100 bond being kept in place.
Okay, the court then is gonna keep the bond at $100. Good luck to you,
And
sir.
Your Honor, we'd ask for no return, though, to that property.
Oh, also, sir, I apologize. Sir, there is no return to 725 Northwest 14th Terrace, Fort Lauderdale, Florida, 33311. Do you understand that, sir?
Yeah.
Thank you very much, sir. Have a good day. Okay, next case is gonna be Jordan Mackenzie Topkins.
He bonded.
Okay, the court finds probable cause. And then the next one's going to be Marquise Devonte Coffey.
He declined the PD.
Okay, is there a Mr. Coffey there? Good morning, sir. You declined the services of the public defender?
Yes.
Okay, the court finds probable cause for count one, possession of cannabis, 20 grams or less, and count two, there's a capious misdemeanor. State?
If Mr. Coffey wants to resolve the charges, the state's offer would be withhold and court cost, judicial notice of time served on both counts.
Yes.
Okay, you want to resolve it today, sir?
Yes.
Okay, raise your right hand. Mr. Coffey, do you swear or affirm to tell the truth, sir?
Yes.
Okay, put your hand down, state your first and last name.
Marquise Coffey.
It's Marquis, last name Coffey, Coffie, sir.
Yes.
Okay, sir, is anyone forcing you to resolve your case today?
No.
Are you under the influence of any drugs or alcohol?
No.
Have you ever been treated for a mental or emotional illness?
No.
Okay, do you understand that you're waiving your right to an attorney in trial today?
Yes.
Okay, keeping that in mind, how do you want to plead to count one, possession of cannabis less than 20 grams, and the capious misdemeanor, which is for possession of cannabis under 20 grams as well, sir. Want to plead no contest, sir?
Yes.
Okay, okay, the court on count 1 and 2 is going to withhold and propose court costs. They are $308 on count 1. Sir, how much time do you need to pay $308 in court costs?
6 months.
I'm sorry, sir, it's going to have to be 308 on each one.
Okay, no matter.
How much time?
You could do 3 months.
Okay, the court's going to give you 3 months to pay the court costs. The court will take judicial notice of the time that you served in jail. Thank you, sir. Good luck to you.
All right.
Next one's going to be John Michael O'Malley. Okay, are you Mr. John Michael O'Malley?
Yes, ma'am.
Okay, sir, the court finds probable cause. You're charged with count 1, DUI, first offense. Count 2, DUI with damage to property or person of another. Count 3, DUI with unlawful breath, over .15 or accompanied by a person under 18 years of age. State, which one is it?
The breath results are above 0.15.
Okay, and texting while driving. State? Bond set at 500, 1,000, 1,000.
Yes, Your Honor, I'm going to be asking for a combination of the bonds that are already set, and should Mr. O'Malley post those bonds, that he be supervised by pretrial release. Noting, Your Honor, first off, that this involved an accident where Mr. O'Malley struck a parked vehicle with enough force that his airbag deployed. Also noting that his breath results were a...
.196 and .182?
Yes, Judge.
Okay.
That could be anywhere.
Okay, so your recommendation is to bond, sir?
I'm fine with the $2,500 bonds, Your Honor. I'm just asking that he also be supervised by pretrial release with an alcohol evaluation, alcohol testing, with the condition no alcohol or intoxicants until further order of the court.
Okay, defense?
Judge, he would be able to post a $2,500 bond, so I'm not making an argument with regards to that. However, I would ask the court not to place him on pretrial release. My understanding is this is his first offense, that he's never had anything prior. And we would just ask that he post a monetary bond. He does live, in the area, so he would come back to court.
Okay, on count 1, the court's going to do a $500 bond. On counts 2 and 3, the court's going to do a $1,000 bond on each count. Sir, you are to consume no alcohol during the course of your of this pending case. Do you understand that, sir?
Yes, Your Honor. No, they do.
So that's no alcohol consumption. Thank you, sir.
Thank you. Oh, Judge, the other thing is I need an order for him to get to property so he can get his debit card to post bond.
Sure.
Thank you.
Mr. Reedy?
Yes, I'll draft that order, Judge.
Okay, thank you.
Thank you.
You're welcome. Jermaine Anthony Lynch?
Mr. Lynch is in the North Broward Detention Center. He indicated to me he'd like to resolve this matter this morning if possible.
Okay. Okay, are you Mr. Lynch?
Yes, ma'am.
Okay, state.
Your Honor, one moment. We'll make an offer. Yes, all right, Mr. Lynch has a lengthy criminal history. Note that he already got, looks like this is his second day in. State's offer would be adjudication, time served on both counts.
Okay, defense?
Did you hear what the state said, Mr. Lynch?
Yes, sir. I would like to take it.
Okay.
Okay, is it, Madam Clerk, is that 293 on count 1? Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, put your hand down. State your first and last name.
Jermaine Lynch.
Okay, Mr. Lynch, you're charged with count 1, drug paraphernalia possession, and count 2, trespassing, occupied structure or conveyance. How do you wish to plead, sir? No contest?
Yes, sir. Yes, Your Honor.
Okay, the court's gonna adjudicate you and time serve you and impose court costs of $293. How much time do you need, sir?
6 months.
Okay. All right, thank you very much.
Thank you, Judge.
Good luck to you, sir. Okay, next one's gonna be Tavares Antone Young.
He's a medical research.
I just wrote medical research. I'll put the date up there, okay? All right, Montrell Ramsley. Sir, please state your name.
Sure, Ramsey.
Okay, sir, the court does find probable cause. You're charged with count 1, carrying concealed firearm. Count 2, possession of a weapon or ammo by a Florida convicted felon. Count 3, resisting an officer, obstructing without violence. And counts 4 through 8, sir, are capiouses for felonies. State.
Your Honor, based on the numerous no bond holds that Mr. Ramsley has, I'm just gonna ask the court to keep the bonds that I believe Judge Merrigan set on the arrest warrant charges.
Okay, defense.
Judge, normally we would ask you to keep it the same. However, he did indicate to me he expects when he goes to court on January 3rd that those capiouses are going to be lifted. So in light of that, he asked me to ask the court if the court would consider something lower than the bonds that are currently set. I can tell the court that he's lived here all of his life, that he is single, he takes care of a 6 and a 4-year-old child, that he has no money in the bank, currently not working, but he does live with his girlfriend, who I believe is present in court, and he does have family members that live here in the area.
Okay, all right.
I would just know, the fact that he expects it to happen doesn't mean it will. And because he has pending charges in front of Judge Dennis Bailey, the arrest warrant charges will also be assigned to Judge Dennis Bailey, so at which time he could address those bonds as well.
Okay. All right, ma'am, please say, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, put your hand down. State your first and last name, your relationship to Mr. Ramsley.
My name is Jessica Evans. I'm his current girlfriend.
Okay. All right, what would you like to tell us today, ma'am?
I just came here to basically get a status on him and, give him moral support.
Okay, all right, thank you very much.
Thank you.
Mr. Reddy or Mr. Barbaric?
That's all I had, Judge.
Okay, so then what the court's gonna do is the court's gonna keep the bond in place, 1,000 for 1, 10,000 for 2, 500 for 3, and on counts 4, 5, 6, 7, and 8, the court is gonna keep the no bond holds in place. Sir, I just wanna remind you, on
There's a
January
sec-
3rd at 8:30, you are gonna be in Division FC for your,
Judge.
first status.
There's additional pages to the findings.
Oh, boy, okay,
Yes.
hold on. Sorry about that, sir. On, charges 9, 10, 11, 12, 13, you have capias for felonies, and, 14, 15, 16, you have warrants for violations of probation. Court's gonna keep them as indicated, and the court does find probable cause.
These are all laws. They're all laws. I know. Yeah, she said probation, but I'm not on probation. It's okay.
It's pre-trial.
Pre-trial, sorry, sir. Okay, next one's Tyrone Salter.
North Broward, Your Honor.
North Broward.
Good morning.
Good morning, sir. Court's gonna find probable cause. You're charged with counts 1, 2, 3, and 4, violation of probation for felony. You're gonna be in Division FG on January 3rd at 8:30 a.m. Thank you, sir. Have a good day. Good luck to you.
Judge, he does have some people here from the community in support
Oh,
of him.
okay, I'm sorry. I apologize. Okay, Mr. Tyrone Salter, we do have people here today. Good morning, ma'am. How are you?
Fine.
Okay, raise your right hand. Do you swear or affirm to tell the truth?
Yes. Yes.
Okay, put your hands down and state your first and last name, please. Your relationship to Mr. Salter.
My name is Jemiah Jones. I'm his girlfriend.
Okay,
And I'm Valerie Brown, his grandmother.
okay. Good morning. Thank you for coming. Is there anything you'd like to tell the court?
I have some papers that he was the reason why he violated, but they throwed everything out in Dade County, and I wanted to know, who do I give those papers to?
Okay, you can hand them, as he's represented by the Public Defender's Office, so you can give them to Mr.
We
Reedy
also,
right
I
over
wanted
here.
to, say he was arrested on the 15th, and, the case was closed on the 6th, so, he's missed the holidays, so we wanted to know, can you find it in your heart to at least give him a bond until his next appearance?
I
He's
can't, ma'am, he
working.
has 4 violations of probation for a felony, I apologize, but he's gonna have to wait till January 3rd at 8:30 in Division FG.
Okay, what
Okay.
about at least house arrest until then he
No,
has
ma'am,
a
we
job?
can't do that,
You can't do that.
all right? I apologize.
And where is FJ? Because we had a hard
FG.
time.
Does anybody
FG
know who
Ju-
FG
it's
is?
Judge Dennis Bailey.
Okay, Judge Dennis Bailey is.
in the North Wing.
North Wing.
Okay, thank you so
in
much.
room
It's on
6900.
on the 3rd,
What time?
6th floor,
on
What
the 6th
time?
floor. Thank you.
at 8:30 a.m.
Thank you, Your Honor.
You're welcome, have a good day. Okay, next one's gonna be Christian Vargas. Oops,
Good morning, Your Honor.
sorry about that. Good morning, sir, you're Christian Vargas?
Yes, yes, Your
Okay,
Honor.
sir, you're charged with 1 count of violation of probation for a felony. You're gonna be in Division FE on January 3rd at 8:45 a.m. And until then, you're gonna be held no bond, sir. Good luck to you, okay?
Okay,
Have a
thank you.
good day.
Thank you, Your Honor.
You're welcome. Stephen Campbell? Court finds, I checked off probable cause. Stephen Campbell?
Sorry, Judge, he declined the PD.
Okay. Are you Mr. Campbell?
Yes.
Okay, sir. The court finds probable cause. You have count 1, violation of probation for a felony. You are gonna be in Division FD on January 3rd at 9 a.m. pending. Until that time, you're gonna be held no bond, sir. Good luck to you, okay? Okay, next one's gonna be Nicholas Damian Jorda Rattray. And I see 3 people approaching.
Good morning.
Good morning. Okay, if you'd raise your right hand, who's gonna testify? You swear
Yeah.
and/or affirm to tell the truth?
Yes.
Okay, everybody state your full name. You can put your hands down. And tell us your relationship to Mr. Rattray.
Good morning. My name is Pamela Rattray. I am his aunt. I've been taking care of Nicholas since 15 years now.
I'm Walter Rattray, his uncle.
Okay, good morning, sir.
Jesse Rattray, his brother.
Okay. All right, state.
Your Honor, the court's familiar with the allegations. I don't see a criminal history, however, I am concerned about these allegations. I'd be requesting bonds in the amount of $1,000 per count, total bond of $6,000.
Okay, sir. Mr. Rattray, the court's gonna find probable cause. You're being charged with counts 1 through 5. Burglary of an unoccupied conveyance unarmed, and count 6, grand theft auto.
Your Honor, I think some of these are attempts.
Doesn't say that on my sheet.
No, but I think that's what some of them are. Even Mr. Rattray, who completely cooperated with the law enforcement investigation of this issue, stated that they tried to attempted to enter vehicles parked in various driveways, and that those doors were locked. Although he did admit to going inside some of the vehicles, it's kind of hard to count that up with the way this probable cause affidavit's been copied, but it looks like at least 2 or 3 of these are attempted burglaries of conveyances while unarmed.
It would be 2, Your Honor. It says in the 3rd paragraph, the defendant admitted to attempting to gain entry into 2 vehicles. And Your Honor, just so the court's aware, when I made my recommendation, I took that into consideration. I also took into consideration Mr. Rattray's cooperation. I still believe, in light of all that based on the allegations of this was basically a crime spree in Lighthouse Point with these vehicles and these individuals. So I'm requesting the bond that I requested.
And I don't bring that up just for the purposes of bond, Judge, but also for the purposes of this court finding probable cause. And I think the state is in agreement with me that attempted burglary of a conveyance should be found on 2 of these charges.
Your Honor, may I speak,
Okay,
please?
just one moment.
Thank you.
Okay, Mr. Reedy, I agree with you on, so that would be, make it counts 1 and 2.
That's fine,
For the
Judge.
regular and 3, 4, and 5, does it matter?
I would have no further probable cause argument.
Okay. All right. All right, so on count 1, this is what the court's gonna do. The court's gonna set bond at $1,000. Count 2, the court's gonna set bond at $1,000. Oh, I'm sorry. Ma'am, you wanted to say something
Yes,
further.
ma'am.
Sorry.
I want to say, on behalf of my nephew, I plead not guilty because my nephew never done this before. Never, ever.
Let's not talk about the facts of the case, ma'am.
And,
Ma'am,
okay.
let's not talk about the facts of the case. What you can talk about is Nicholas a good kid? Does he
Yes,
go to
well,
school?
he's
Is he
enrolled.
working?
Right now, he worked for UPS, and he was working for UPS now, but also Discount Auto, and we work every other week with the church with the Feed the Homeless. We have a program that go on every other week where we feed the homeless. And if I had to pay $1,000 here and $1,000 there, well, I take care of children for the state of Florida for the last 30 years. And if I have to pay out that, I can't help the homeless and other people that is in need. And Nicholas is already enrolled into school for in January. He already enrolled in BCC in school. Like I said, he's always home. We attend church every Sunday. If I don't go to church, he's there with the other kids, taking them to church.
Okay, go ahead.
I'd just like to add to the idea that, yes, we are a family that's very involved in church. We go to the conventions with the youth. We have youth camp. He's always been very involved in the church community and in feeding the hungry. But regardless of the situation, we have to, because of what happened over the holiday, we have to have a disciplined talk with him as a family, because we are joined together. This is my sister, and we're a tight-knit family, and because of what occurred. But she really cannot afford that bond, and she's doing what she can for her nieces and nephews. This is his brother, and as she said, she's had them for about 15 years. She had to take them, and their mother doesn't give a dollar to their care, has never given a dollar to their
And I'm
care.
doing everything.
How much bond do you think you could afford?
Right now, I need to go get my medication. Tell you the truth, I'm on medication, and I forgot that I left out so soon this morning to take it. But I've lost some of the kids in my care, and I don't get nothing. Well, I'm supposed to get support for the kids, but I don't get nothing from the parent or the absent parent.
How much money do you
Nothing.
think you can afford to come up with for bond?
Right now, probably $100.
And would Nicholas be living with you?
Yes, sir.
And has he been living with you?
Yes, sir.
How long has he lived with you?
15 years.
And you'll make sure he comes back to court?
Yes,
if
sir.
these charges get filed?
Yes, sir.
And Your Honor, I certainly sympathize, and
Mr. Reddy?
No further questions.
that's what I'm sorry, that's what I figured. And I certainly sympathize with this, with the information this family has provided, Your Honor, but at the same time, it has to be balanced with, we have allegations here, and there's very strong evidence that Mr. Rattray, along with, it appears 400 individuals, decided to go into Lighthouse Point, and whether they were successfully able to get into all but 2, or they got into 3 others, burglarized 5, or attempted to burglarize 5 vehicles, while in the process of being in possession of a stolen vehicle. There has to be a balancing to ensure that the property of people living in the community is protected, and I don't know that even a $1,000 total bond, even with other conditions, would necessarily ensure that.
Just if I could, Just to kind of reiterate what the family said, but he's lived here for 13 years. He has no children. He does work for UPS and for an auto parts store. So he has two good jobs as far as that goes. His family is here. They're very close. Obviously, they keep watch over him. They do a lot of work in the community and also with the church. I don't know if the court would consider to perhaps, because he has no prior record, because he does do community service work out for the community, I would ask the court to consider maybe reducing the bond on the two attempts and maybe even a third case. If the court would ROR him on 2 or 3 of the counts and leave the bond at $1,000, that may help the family in order to afford the bond.
To be honest, and while yes, working for UPS is a great job, in light of these allegations, it causes me a little concern. I don't know what his actual position with UPS, but it causes me a little concern.
He done lost the job now because he couldn't go in.
I'm just saying, it's been brought up multiple times, and it just causes me some concern that he would be in a position where he would have access to other people's packages and whatnot with these allegations.
But he's never had a problem before, and he's worked
That
there.
we know of.
What is his position with UPS?
He's not worked, he done lost the job because he didn't go in.
It was a seasonal
Seasonal.
job that he just got, but the fact, Judge, is, my sister requires all the kids of age to be at home by
A
11
certain
o'clock.
time.
She's very strict and she does not play.
Even on that night, I called him that night and asked him, he said he was heading home.
What about-
And,
Go ahead, ma'am, I'm sorry.
yes, sorry. Even that night, I called him that night to ask him where he was because he normally be home. We don't go out like that. If it's not at church, and like I said, if I'm not going to church, he's taking the kids to church. For me, if I'm ill and I can't get up, some mornings I can't get up, he take care of things for me. He makes sure the children go out to the church and stuff, to the programs. Even officer that be at our church, they have a program that they keep the kids in. They look for Nicholas a lot of times because he head off some of the programs with the children, with Officer Nichols.
And Your Honor, I have no doubt his aunt has these rules in place. The problem is, it would appear it wasn't followed because according to a license plate recognition reader in Lighthouse Point, Mr. Ratray's vehicle was seen was detected in this neighborhood at 11:30, the night the burglaries allegedly occurred.
Okay, this is what the court's gonna do. Okay, the court finds probable cause, as I indicated earlier. On count 1, the court's gonna set the bond at $1,000. At count 2, the court's gonna set a bond at $1,000. On counts 3, 4, 5, and 6, the court's gonna ROR him. However, the court is gonna put him on GPS level 2. Sir, you are to maintain at least 1,000 feet from Northeast 40th Street, Lighthouse Point, Florida 33064. Do you understand that, sir?
If the court could inquire, I know there's, I'm sorry, I'll let him respond to your question first.
Do you understand that, sir? Sir, do you understand you're supposed to maintain 1,000 feet from Northeast 40th Street, Lighthouse Point, Florida 33064?
Yes, ma'am.
Okay, and you're also to stay away, have no contact, direct or indirect, with any of the owners of these vehicles, and particularly with Thomas Mullen. Do you understand that, sir?
Yes, ma'am.
And the
Okay.
only other thing I would ask, if the court could inquire, I know it makes reference to his cousin in the report.
That's what I
If
was
it could
gonna
inquire
bring
if he
up also.
resides, I was gonna ask if he resides with his
Do you
cousin.
reside with your cousin, who's also charged in this case?
No, he's not even allowed to to my house.
Okay.
He came Christmas and I told him he didn't have
Okay,
no
hold on,
business
ma'am.
there.
Then I would just ask if the additional condition that no contact with any of the co-defendants.
Okay, name?
I don't have the names for them, and frankly, Judge, for all I know, they may be juvenile, so I would just
Okay,
ask
I
at this point in
understand.
time.
Okay, sir, you're to have no contact, direct or indirect, with any of the co-defendants in this case, okay?
Yes, sir.
Your Honor,
Okay, and the court is gonna waive the costs of the GPS. Anything further, pretrial?
Just want to confirm, for the purpose of my order, count 1 and 2, he will post a bond of $1,000 each.
Correct.
Counts 3 through 6, he will be ROR'd.
Correct.
However, he's going to be placed on pretrial. The ROR stands to the not having to post a monetary bond. However, he's going to be placed on pretrial on all 6 counts. Is that correct?
That's correct.
The court is placing him on a level 2 GPS monitor, and is waiving the $5 per day cost. Is that also correct?
That's correct,
And he's to have no contact with any of the co-defendants.
correct.
Your Honor, how could he go to work if he on GPS?
Hey,
Your
man, he's
Honor.
gonna have to give him his schedule. I'm also gonna impose a curfew on him
Okay,
if
what
he is
time is
not
that
working.
curfew?
From
Would he be able to go to
7
church?
p.m.
7 p.m.
to 6 a.m.
Daily curfew from 7 p.m. until 6 a.m.
unless he's at work.
And if he is at work, Your Honor, we would already have that scheduled. I did hear the aunt ask if he is permitted to go to church.
Right.
And one of the conditions, if the court does allow that, is they are allowed to have time to attend religious services.
Okay, that's fine.
Thank you. And,
Okay.
and he cannot leave his home without prior scheduling with pretrial. He can't leave and then call pretrial. He will be wearing a GPS monitor. We will know where he is at all times
Okay, thank you very
And
much.
how long this will be?
until,
This will be during
Ma'am?
the pendency of his case, ma'am.
Oh,
Unless
okay.
another judge changes that order, okay?
Okay,
Thank
thank
you very
you.
much for coming in, ma'am. Good luck to you.
Thank you.
You're welcome. Okay, Andrew Joseph Moralt.
North Broad, Your Honor.
Hello,
Okay, your name, please?
Andrew Joseph Merrill,
Okay,
Your Honor.
good afternoon, good morning, sir. The court finds probable cause, you're being charged count 1, burglary of a dwelling or a structure.
Your Honor, I'm sorry, I spoke to the arresting officer. There was a misspoke. It should just be burglary of a conveyance, not armed.
Yes, I was gonna make that point myself.
Okay, and what's the officer's name?
It's Officer Blunt who wrote the report. That's who I spoke to.
B-L-U-N-T?
Yes, he authored the PC affidavit.
Okay, sir, the court finds probable cause, you're charged with burg dwelling of conveyance, and that is unarmed per the state attorney's office and Officer Blunt. Count 2, grand theft between $300 and $5,000, and count 3, dealing in stolen property. State priors pending and recommendation, please.
Your Honor, Mr. Merrill's criminal history, he had 2013 burglary of a conveyance, grand theft, misdemeanor possession of cannabis and drug paraphernalia. State's recommendation on count 1, the burglary would be $3,500. And in light of the circumstances, asking for $1,000 on count 2 and $3,500 on 3.
So that's 35,
It'd be total 8,000.
1 and 35, 1,000 and then 3,500?
Yes, ma'am.
Okay.
Judge, unfortunately, there was a bit of a delay bringing Mr. Merrill down this morning, not through any fault of his own, so I didn't really get a chance to speak to him as to his ties to the community. I'd like to inquire now if the court doesn't mind.
Sure, you can speak to him privately and we can resolve this.
Let me see if that becomes necessary. Mr. Merrill, can you afford that bond?
Is it over $1,000?
Were you asking 3,500 on count 1?
8,500.
8,000?
No, I'm sorry, 8,000.
Oh, no, definitely not.
Well, how much bond could you afford?
I could, realistically, 2,000.
Are you working?
No, I have disability and, I would get help from my parents, but that would be tough to get $8,000.
Let me just have a moment to call him, Judge.
Sure. Sir, you can step inside and speak to Mr. Reddy.
All right, thank you. Thank you. Hello. Someone's gonna be bonding me out.
Okay, why don't we have the deputy at North Broward mute the mic?
Yeah, don't worry about it.
Thank you. case are you here on? Patterson?
Your Honor, in speaking to Mr. Merrill,
Yes.
he has been living here in Florida all of his life. He's currently not working because he gets disability. He's been living with his parents for the past 4 years, and he's given me their name. Actually, he didn't give me their name. What's the name of your mom or dad?
Bill and Jenny Merrill.
He would be living with his parents if he was released. He thinks they can maybe come up with maybe enough bond for $2,500, but $8,000 seems to be a little bit out of their range. But I'll be giving them a call later on to see how well they can do. But I'd ask the court to consider a lower bond than what the state is recommending.
My other additional concern, Your Honor, I did a little searching and I saw when he was out on release on his burglary case, on 2 separate occasions, apparently he violated his release conditions and he had to be taken into custody on court orders.
Defense, anything further?
No, Your Honor. Just again, that there's limited financial resources available in the family.
Okay, the court's gonna set bond on count 1 at $2,000, on count 2, the grand theft auto $1,000, and the dealing in stolen property, $3,500. Thank you very much, sir. The
Your Honor,
court does find probable cause.
I'm sorry, we'd also just ask for no victim contact.
Oh, sir, there's
Yes.
no victim contact. The victim's name is Mario Legare, Legare, and that's direct or indirect or through social media or any other means. You understand that, sir?
Yes.
Okay, thank you very much. Good luck to you, sir.
Thank you.
Sergeant Warren, 88.
Okay, you said that you're here on Patterson? Okay, I didn't see that case. Anybody see that?
I'll check, Your Honor.
It's not, yeah, yes, Your Honor.
Is it on the change of charge docket? Pardon? How many pages, Willie?
25, go down like 5 pages.
Jaquan Patterson.
Yeah.
Yeah, and Your Honor, if you want, he's one of, I believe, 4 co-defendants, so maybe. No, I know, I'm just saying he's one, when you find him, he's one of 4 co-defendants.
I see it. Okay, we're gonna be to it shortly, okay, ma'am? All right, next one's gonna be Decorian Delhome, or Delhomey. Okay, sir, please state your name.
Corey and Delhome.
Okay, Mr. Delhome, the court does find probable cause. You are charged with 1 count of dealing in stolen property. State?
Your Honor, the state is going to be asking a bond increase to $7,500, and should Mr. Delhome post his bond, that he be supervised by pretrial release with a GPS monitor. Your Honor, Mr. Delhome was arrested October 30th, and he was charged with the following offenses: burglary of a structure, theft, battery, burglary of a structure, and theft. He posted bond and was released Sunday, December 24th. And now within 3 days of that release, he's before the court again. And additionally, he has priors 2015, unlawful use of false name ID and trespass, 13, delivery of controlled substance, VOP, 2013, possession of cocaine, VOP, 2013, possession of cocaine, possession of controlled substance with a VOP, theft 2011, under the name Michael Freeman, and 2011, resisting without violence and theft under the name Michael Freeman.
Okay, defense.
Judge, I can tell the court that he has lived here most of his life, that he's currently not working, and he has a child that's 1 year old. He indicated he's not failed to appear in court before. He does have family members that live in the area, so he's not a flight risk. He indicated he has a little bit of money, but not a lot. I don't believe he'd be able to afford what the state is requesting. We would ask the court to keep it at $3,500. He may be able to post bond at that.
first and foremost, Mr. Delhomme, the court is gonna order no contact, direct or indirect, with the alleged victim in this case, Elizabeth Desjardins, Desjardin. Do you understand that, sir?
I don't even know who that is.
Okay, well, I'm just letting you know.
Your Honor, it's a little concerning, and I want to bring to the court's attention. So far, I've already seen one case where a no bond capias was issued because Mr. Delhomme failed to appear in court.
Okay, great. All right, so as to count one, the court is gonna order a $3,500 bond. The court is gonna do a GPS level 2. And the court will waive the cost of the GPS monitor. Anything else, Madam Pretrial?
$3,500.
Okay, that's it. Good luck to you. Thank you very much.
Thank you, Judge.
You're welcome. Okay, next one's gonna be Dead Reart Homes.
Yeah, just stapled together. It has the case numbers there.
Good afternoon, sir. Please say your name. Okay, you're on mute, I believe.
Adrian Holmes.
Okay, Mr. Holmes, the court does find probable cause. You're charged with count 1, seller possess, counterfeit, schedule 1, 2, 3, or 4 drug. Count 2, resisting an officer without or obstruct without violence. And count 3, possession of cocaine. State?
Your Honor, I'm asking.
Indicated he's gonna represent himself.
Okay.
Your Honor, Mr. Holmes is wrapping up a 10-year prison sentence for second-degree murder. Just requesting that these bonds be kept in place.
Okay. Defense? I'm sorry, sir. Would you like to respond?
Yeah.
Don't talk about the facts of your case, sir. Just address the
Yeah,
bond issue.
I'm not going to speak about that. He said that he was requesting that the bonds be kept in place, right?
Yes.
I'm asking for a reduction because the charges those charges is in 07. They said the charges was in 07. I'm just trying to figure out. I was a juvenile at that time, so I mean.
These were direct filed.
They were direct filed, sir, as an adult.
Well, I mean, will you grant my reduction? Because I'm asking. They gave me a bond for $2,100.
What bond are you saying you could afford, sir?
I can pay $1,000.
Your Honor, we would just request, and that's why I mentioned, considering that his prison sentence is ending for second-degree murder, we'd ask that it be left to his assigned judge, any bond modifications.
All right, this is what the court's gonna do, sir. The court is gonna keep the bonds in place, 1,100, 1,000, but that's without prejudice for you to go before your division judge and seek a bond reduction, okay? And that's because of your, other case. Thank you, sir. Have a good day. Next one's gonna be Robert Davis. Court finds probable cause. Mr. Davis, you're charged with 1 count of violation of probation for a felony. The court's gonna keep you on a no bond hold. You do have a court date for your violation of probation in Division FG on January 3rd, sir, at 8:30 a.m. Okay, sir? Good luck to you. Next one's going to be Robert Lee Williams Anderson. Okay, are you Mr. Williams Anderson?
Robert Williams.
Okay. Sir, the court's gonna find probable cause. You're charged with count 1, possession of cannabis, 20 grams or less. Count 2, driving while license is suspended, 3rd or subsequent offense. And counts 3, 4, and 5 are for capious misdemeanors. You have a status hearing, I can tell you, on January 2nd at 1:30 in Division Z as in zebra D. Okay, state?
Your Honor, those cases are before Judge Zeller in drug court, so I just ask that they be kept in place.
Even the driving while license is suspended?
Considering he was out on a DWLS and drug court, I'd ask that the 750 be kept in place as well. Also looks like there's failure.
So
These are
there's
from
no
failures
bond
to appear.
holds in
Those are at a drug court, so I'd ask that they be kept in place.
Okay. Okay, defense?
Judge, in light of the fact that he has 3 no bond holds, I would just ask that you keep the bond in place for counts 1 and 2.
Okay, the court's gonna keep them in place. And counts 3, 4, and 5 are no bond holds. We'll see your Judge Zeller on January 2nd at 1:30, sir. Good luck to you. Okay, next one's gonna be Vidal Alfredo Morales. Vidal Alfredo Morales. Are you Mr. Morales?
Yes, ma'am.
Okay, sir, the court does find probable cause on count 1. You're charged with grand theft between $300 and $5,000. Count 2, grand theft auto, and count 3, probation violation or community control. We don't have a future court date for that.
It's out of Dade County.
Pardon?
It's out of Dade County.
Oh, Dade County, okay. All right, recommendations? Let's go 1 and 2.
Just because of the no bond on 3, I'm just asking that those are kept in place.
Okay, defense?
Judge, if I can have 1 second, I missed him earlier.
Sure.
And if not for the no bond hold, I think there'd be a pretty good argument based on the facts and the probable cause affidavit to at least consider a bond reduction. But I don't know what his ties to the community are, so I guess we'll find out in a second.
Okay. Thank you very much.
Judge, he's trying to go back to Dade County. This is an employment dispute, apparently. What I would be asking the court is this: he wanted to see if he can get back to Dade County so that they can handle the violation of probation first. I don't know if the court would consider setting a bond of $500 on counts 1 and 2. He can't post a $2,000 bond, and apparently the company's holding money that he has, but. Be that as it may, he may be able to post on counts 1 and 2, get down to Dade County to resolve that, and then come back up here and resolve the Broward County cases.
Considering he's on probation for an offense that carries a minimum mandatory prison sentence.
Say that again?
Considering he's on probation for an offense that carries a minimum mandatory prison sentence, I would ask that, I believe $2,000 total bond for alleged felony violations is appropriate.
Can you tell them that about the bond? Doesn't matter. Just so I know.
Okay, this is what the court's gonna do. On count 1, the court's gonna put the bond at $1,000. And count 2, the court's gonna put the bond at $500. Sir, you're gonna be held no bond on count 3. Good luck to you, sir. Okay, next one's going to be DeAndre Darrell Smith. DeAndre Darrell Smith. Okay, sir, please state your name.
DeAndre Smith.
Okay, good morning, Mr. Smith. The court does find probable cause. The charge with count 1, petty theft, first degree between 100 and 300. Count 2, resisting an officer or obstructing without violence. And on counts 3, 4 is a capias for a misdemeanor, and count 5 is an out-of-state hold for a felony, which you're being held no bond on that count. We do have a hearing for a status in Division MJ on January 4th at 11 a.m. State?
Your Honor, in light of the out-of-state hold, I wasn't intending to make an offer, and I'm just asking that the bonds be kept in place.
Say that again?
I wasn't intending on making an offer, and was just going to ask that the bonds be kept in place.
Okay. Anything further, defense?
These two, she can't change, so
No, Judge, we would just ask that it stay the same.
Okay, the court's gonna keep it the same. 0 on count 1, count 2 is 100, count 3 and 4, 500 each, and count 5 is no bond. Don't forget, sir, you're gonna be going before your judge on January 4th at 11 a.m. Good luck to you. Next one's going to be Lashad Thompson, and then after that is gonna be Cedric Campbell.
Judge, Mr. Thompson's bonded.
Okay. Okay, Cedric Camper. And then after that is going to be Mario Antonio Chavez. Yes. On who? DeAndre? Smith. Madam Clerk, can I have DeAndre Smith back? Okay. Thank you. Okay, go ahead. Which one, for the out-of-state? Oh, yeah, okay.
CR 16002930H4.
Okay, CR 16002930H4, correct? Okay, you're welcome. Okay, so Cedric Camper?
Yes, ma'am.
Okay. Sir, you're being charged, the court does find probable cause on count 1, false ID given to a Leo, count 2, possession of cannabis, 20 grams or less, count 3, driving while license is suspended, and count 4 is an out-of-state hold felony. Okay, state?
Your Honor, in light of the out-of-state hold, I'm just requesting
Same thing?
everything, yes.
Okay, defense?
Thank you, Judge.
Okay, do I have the right case number?
Yes.
Okay. All right, so we're gonna make 1 1,000 and count 4 is a no bond hold for the out-of-state felony. Good luck to you,
Actually,
sir.
count 1 is 100.
100, I'm sorry.
No problem.
Thank you. Okay. Marco Antonio Chavez, and then after this, we're gonna take a break just for 1 moment. Marco Antonio Chavez. Okay, good morning, sir. Are you Mr. Chavez? He what?
Good morning.
Okay, good morning. It is gonna be a good morning because I'm gonna tell you, your bond's been posted, sir, okay?
Oh, thank you.
You're welcome. Court does find probable cause for possession of cannabis over 20 grams for $1,000. Thank you, sir. Good luck to you.
Thank you, Judge.
You're welcome. Okay, next one. Well, let's take a break for just a moment, okay? Back. Okay, Larry Travis Williams.
Oh, I'm sorry, come on up. Good morning, Mel.
Good morning, sir. How are you?
I'm sorry, I didn't know I was on. I'm blessed. I'm blessed. Thank you, Lord.
Okay. All right, sir. The court is going to find probable cause. You're charged with count 1, attempted felony murder, specified felony, and count 2, possession of a weapon or ammo by a convicted Florida felon.
And Your Honor, it's going by the warrant. I know that's what it says on the booking. It's actually attempted premeditated murder with a firearm.
Okay.
Your Honor, that is a punishable by life offense. The state, and I've provided a copy of the warrant affidavit to Your Honor and defense counsel. Your Honor, the
Are you
state.
seeking a finding of proof evident presumption great?
Yes, Your Honor, relying upon the affidavit for first appearance purposes only, Your Honor. Noting the allegations are that Mr. Williams, one moment. That the alleged victim was seated in his vehicle while in Hallandale Beach, Florida, Broward County. He observed a black vehicle pull up aside behind his vehicle. He observed the defendant exit the vehicle and fire shots at him from an Uzi-style firearm. One bullet struck the alleged victim under his arm, striking his liver and colon. The alleged victim was attended to by officers and fire rescue, at which time he informed officers that Larry Williams had shot him. He was rushed to the hospital for life-saving treatment, and the projectile was recovered. Noting that the alleged victim did positively identify Larry Williams from a six-person photo array, further noting that he is personally familiar with Mr. Williams and that he's known him for several years. Would also note that the alleged victim provided a description, a physical description of Larry Williams and his vehicle, Your Honor.
Well, we would agree that there might be enough evidence here in this affidavit for the court to make a finding of probable cause. It certainly does not give rise to proof evident presumption great. That is the highest standard that we have in the criminal justice system. And that standard has not been met here. Everything in this affidavit is based solely on the testimony of one witness. This court has not had an opportunity to observe that witness. This court has not had an opportunity to gauge that witness's credibility, or consider any possible motive for this witness to misrepresent facts to the police. There is no statement by Mr. Williams, who needs to just stand still right now. Mr. Williams, thank you. There's been nothing from the state as far as any physical evidence, because there is none. There is no gun recovered. A bullet has been recovered from the victim, apparently, but it has not been matched ballistically to any other evidence. If these two gentlemen did know each other, then the identification is meaningless because he knew him. And if he's not telling the truth about who did this, then that's all something that should be determined later. And I agree that there is probable cause here, but there is certainly not proof evident presumption great. The state likes to rely on Ysadra v. State as a grounds for the court having the legal authority to find proof evident presumption great based on a probable cause affidavit or affidavit, but this court's not under an obligation to do so. And Ysadra was a very, very strong case for the state. There was a confession. There were independent witnesses. There's so many things that are not contained in the facts of this case. This court can certainly take the severity of the allegations into account when determining what bond should be set. But to make a finding of proof evident presumption great based on what's been presented to the court this morning, I think would be an incorrect ruling, and I would ask the court to set bond for Mr. Williams.
Okay.
Your Honor, I would just, and because it was mentioned that proof evident presumption great is the highest burden, I just want to, stating from case law, Your Honor, the 4th DCA in Gallo v. Lamberti, and it's 972 Southern 2nd 305, and determining proof evident or presumption great, cited to State v. Arthur, stating the state's burden in order to foreclose bail as a matter of right is to present some further evidence which, viewed in the light most favorable to the state, would be legally sufficient to sustain a jury verdict of guilty. And it says this evidence may be presented in the form of transcripts or affidavits.
I don't think there's enough evidence here to get to get a jury to convict. I don't think there's a good faith basis in a likelihood of conviction based on an unsupported hearsay statement being presented to this court at this time.
And, Your Honor, one moment.
Says Sistine Jean, while he was seated in his vehicle, he observed a black vehicle pull up in the street behind him. And Mr. Jean, or Sistine Jean, observed the defendant exit the vehicle and fire an Uzi-style firearm at him 4 times.
Your Honor, I would note also this court, citing Elderbroom v. Knowles, notes that essentially the defense, if the defense is able to contradict in material respects the evidence such that substantial questions of fact are raised as to guilt or innocence of the defendant, then the trial court may properly find that proof of guilt is not evident or the presumption of guilt is not great. Frankly, at this point in first appearance, I don't believe that Mr. Reedy's speculation is enough to raise material, contradicts the evidence in material respects.
There's no speculation. This is a probable cause affidavit that is void of any physical evidence and void of anything other than one witness's hearsay statement. There's nothing else other than the statement of the alleged victim to support the state contention that they have somehow managed to meet the highest burden that exists in the criminal justice system.
Okay, Mr. Williams, I have reviewed the probable cause affidavit filed in your case, and I find probable cause, as I stated earlier. I further find the proof of guilt to be evident and the presumption great. Therefore, on count 1, you're to be held without bond until further order of the court. This order is without prejudice for you to file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. As to count 2, the court is going to set bond at $100,000. You're to have no contact, sir, direct or indirect, with the listed victim in this case, Sistine Jean. Do you understand that, sir?
Do you understand what she's explained to you?
Yes.
Okay, just tell her, say yes.
Yes, I do.
Okay.
Do you think,
Don't ask me any questions, sir. Okay. Anything else, Mr. Linder, with any other stay-away orders from anybody?
Nothing further from the state judge.
Okay. Thank you very much, sir. Good luck to you,
And
okay?
we would invoke the defendant's rights to remain silent and right to not be interrogated by the police or their agencies without his attorney present.
Okay, so noted. Thank you.
Thank you.
Okay, next case is going to be Demetris Amhad Irvin. Next one's going to be yours, Patterson, okay? Next one after that's going to be Jaquan Patterson. Okay, are you Mr. Irvin?
Yes, ma'am.
Okay, sir, you're charged of count 1, burglary of an occupied conveyance unarmed, and count 2, petty theft, 2nd degree. The court does find probable cause. State, priors pending, and recommendation, please.
Your Honor, I see no criminal history based on the allegations. State would be requesting a $1,500 bond on count 1.
If the court is inclined to place this defendant on pretrial supervision, we have verified his information. I understand he has no prior record. We're going to ask that if the court is going to place him on standard, that he must report to the pretrial office at least once per week in person and twice per week by telephone.
Your Honor, I have no objection to that. The only other conditions I would ask for,
No contact with the co-defendant.
and no victim contact, and as Ms. Wright correctly stated,
And a what? What's,
no contact with the other co-defendants. We're, I believe, the next 3 cases on the docket.
And he's the only one I'm asking for.
For 1. Yeah, it's doing the trick.
okay, defense?
Because I can tell the court that he's lived here all of his life, that he has no children, he currently isn't working, and he has no money in the bank. He lives with his mom. He did indicate that he would be amenable to doing the pretrial release and reporting in the 1 time a week. The only issue with that is that his brother, who is the co-defendant, also lives with his mom, so they live in the same place. If the court can delete that condition, if the court can delete the no contact with his brother, one issue, that's the only thing that we had a sticking point with.
Okay, what's his brother's name?
Which brother's name? Which brother's name?
He don't stay there.
He just
If
said
I
he
have one
doesn't
second,
stay
sir.
there. He's not sure? He just said my brother doesn't stay there.
Then it shouldn't be a problem.
Does he know?
Okay,
What he's indicated, Judge, is the brother doesn't live there, but apparently comes over to visit, and that's the issue.
Well, Your Honor, frankly, out of my concern about what they were allegedly involved with together for the time being, since they don't live together, they don't have to be around one another.
Which one's the brother?
yes,
I'm
you
guessing
can.
it's Brandon Ivory since they have the same address.
Okay, so, anything further from the state?
No.
Okay, so you're stating that you agree with, standard pretrial, but that he report one time a week in person?
I'm fine with whatever conditions
Did
pretrial
you say once
wants.
or twice in person?
I
heard-
want him twice a week by phone and once in physically coming into the pretrial office. If he believes that's an undue hardship, then I would recommend he be placed on my GPS.
What's your response, defense?
Judge, I mean, this is an issue, I mean, I can tell him to leave the house. The problem is if the brother comes over, at midnight, I don't necessarily want to
about the brother, no.
trees so that his brother's not there. And I don't think adding a condition of GPS to it, I don't think that's really appropriate.
Well, let me just make sure, they said that they wanted him to phone in 2 times per week.
And
And
appear
go
in
in
person
person
once.
and
Yes.
appear in person 1 time per week, and if that was too much of a burden for him, then a GPS monitor was the alternative.
I got my phone, at the police took my phone. You mean, one second.
It's 3 of them, right? It's 3 of
It's
them?
not a hardship for him to do that, Judge.
Okay, good, so then we'll
It's
do
not?
standard.
He indicated that it's not, correct, it's not a hardship. You would call in 2 times a week to the office, correct?
Yes, ma'am.
And you would also report in 1 time in person, correct?
Yes, ma'am.
And
Okay.
it's not a problem for you.
No, ma'am.
Okay, so Mr. Linder, as to count 1 and 2, you would say ROR standard pretrial?
Yeah, I'm fine with that.
Okay, so the court's gonna, ROR on counts 1 and 2. Place the defendant on standard pretrial. Sir, you are to call in 2 times per week. And you are to appear in person 1 time per week. You're also to have no contact with the alleged victim in this case, who is?
Tamara Tapper.
Tamara Tapper. Did you hear that, sir?
Yes, ma'am.
Okay, and you're also not to have any contacts with the co-defendants in this case.
And Judge, what if the brother were to come over to visit the mother?
Then the mother's gonna have to either visit him outside the house, or, he's gonna have to leave, one of the 2.
Okay, and I'll advise him of that.
Okay,
as
there's no
the court
contact.
did.
Okay.
And,
And when's he
just
gonna have to report to the pretrial office?
today, he can show up today.
Okay, sir, you're gonna have to report to the pretrial office by?
Today as soon as he gets out, and if it's after 4, then tomorrow morning between 8 and noon.
Okay, sir.
Your Honor, for the
Okay,
purpose,
Mr. Farber, can you explain that to your client?
for the
I think,
purpose
Judge, we have a
of my
map here
court
at the jail
order.
that we give him, so it lets them know all that information.
Okay, and it does let him know that he doesn't get out in enough time today. He has to report between 8 and 12 noon tomorrow, and if he doesn't,
Yes.
Your Honor, just also, if the court could give me the names of the co-defendants, so I could write that on my order.
okay, I'm gonna ask the state for that information.
Go ahead. How many are there? Patterson.
Okay, thank you very much. Then the next one's gonna be, you're welcome, Jaquan Patterson. Thank you. Okay, and we have someone present in the court today.
Jaquan Patterson.
Thank you for your patience in waiting, ma'am. Raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, please state your name and your relationship to Mr. Patterson, please.
Terrell Hall, his mother.
Okay. State. We're on Jaquan Tyrell Patterson.
Your Honor, he has no criminal history, and because of that, I have no objection if you give him the same release conditions as his last co-defendant.
Okay. All right, Mr. Patterson, the court does find probable cause. You're charged with count 1, burglary, unoccupied conveyance, unarmed, and count 2, petty theft, second degree. Defense?
Judge, he's amenable to the same conditions as the last gentleman.
Okay. Is there anything you'd like to tell the court, ma'am?
I'm sorry, I didn't pay attention to what the last defendant was.
Okay, so basically, they're gonna put him on standard pretrial release with a couple conditions. He's gonna have to telephone in twice every week, and then appear one time per each week as well.
Okay. And I'm not
then
familiar,
he's-
oh, I'm
hold on.
sorry.
That's okay. And also, he's to have no contact with any of the co-defendants in this case.
Okay, so I'm not familiar with the co-defendants, but he's still currently in high school, so I don't know if any of them go to the same school. How would that affect the situation?
Obviously, that it has to be willful contact. If it happens, if they go to school together, that I would ask that not be considered a violation.
Okay.
Okay.
Not a problem. Okay, so the court's gonna keep the bonds. They're gonna ROR on each one. Standard pretrial release. Except for he's gonna report one time per week in person.
This is just until they actually go to trial, correct? Because
Correct.
I'm responsible
This
for
is-
getting him there, so I need to know how often a week I do work during the week.
Okay, what time do you work in?
Okay.
He may have to get a bus pass, because he must show up once a week.
Your Honor.
His failing to show up will be a
No, please go ahead.
violation of his pretrial supervision warrant for replacement.
Okay, I'm just want to make sure he has time after school to make it to wherever he has to be. So that's why I wanted to know, like, I know it's once a week, but where is it located? What's the times for him to be there? Okay, so he has to come at least once a week. Okay.
We have to figure these things out, how to do these things, but, Your Honor,
I'm sorry?
I was addressing the court, while we have family here, if we could verify an address also.
Okay.
4092 Lakeside Drive. 4092 Lakeside Drive, Tamarack, Florida, 33319. It's an apartment, but 4092 is the number. 33319. And I've never been
It's
placed in this
actually on the
situation,
booking.
so when I ask questions, I'm asking for knowledge wise. Thank you.
It's actually, Patrice, the address is on the booking report. This is permanent address.
Terrell Hall. Yes, ma'am. Okay.
Okay, we'll go off.
Okay.
Or tomorrow morning between 8 and 11. I know school is out, so he could come in the morning. They'll fill out all the paperwork, he has to sign some things, and then he'll have to report them, let him know
Okay.
when you have to report, you have to come in person at least once a week, and twice a week by phone, he must call in.
Okay.
Failing to do any of those things will result in a warrant being taken to be preserved.
On Patrice. I need Mr. Patterson back up. I need him to hear this. Go ahead, Patrice.
Failing to report, either in person or twice per week, will likely result in a warrant being placed for his arrest. The fact that he's going out without any bond, sometimes the judge will bring him back in and he will be held without a bond.
Okay.
All right, sir, so
Thank
let me
you.
tell you what I'm gonna do. I'm gonna place you on standard pretrial release. you are gonna report 1 time per week in person. It's your responsibility to get there, sir, okay? The second one is you're gonna call in to pretrial 2 times per week. You're gonna have no victim contact, direct or indirect, and you are gonna have the condition number 4, no contact with the co-defendants, okay? If they do go to your school, you can attend school with them, but you are not to have any conversations with them, okay, sir? Do you understand that?
Yes.
Okay, good luck to you, sir.
Thank you.
Okay, next one's gonna be Brandon Rashad Ivory. You're welcome, ma'am. Good luck to you. Okay, sir, the court does find probable cause. Count 1, you're charged with burglary, unoccupied conveyance unarmed, and count 2, petty theft. Is this another co-defendant?
Yes, Your Honor.
Okay, state.
Yeah. Your Honor, I'm gonna be asking for a bond on Mr. Ivory. He does have a criminal history. 2013 felony credit card fraud and grand theft, 34 months in Florida State Prison. 2013 felony theft, 34 months. 2011 burglary of a conveyance, criminal mischief and theft. He violated probation, 34 months in state prison. 2010 burglary of a conveyance, grand theft, violation of probation, 34 months in Florida State Prison. I'm going to be requesting $5,000 bond on count 1 with no victim contact and no contact with co-defendants.
With Tamara Tepper.
Yes, Judge.
Okay, defense.
Judge, I can tell the court he's been a resident here all of his life, that he works for a roofing company. He has family members that he works with. He works for his grandfather, is that correct?
Yes.
And he lives there as well. He does have family members that live here in the area. He does not have a lot of money at this time. He said that he can only afford up to basically what would be a $1,500 bond. I don't know if the court would consider setting a bond at $1,500. And he is also amenable to being placed on pretrial release if the court were to give him a bond of $1,500.
Oh.
Okay, the court's gonna find probable cause. If I haven't said it already, on 1 and 2, the court's gonna set bond of $1,500. On count 1, count 2 is gonna be ROR. The court is gonna place him on GPS level 2, waive the costs of supervision. GPS level 2. Sir, you are to have no contact, direct or indirect, with the alleged victim, in this case, Tamara Tapper. And you are to have no contact with the co-defendants in this case. Do you understand that, sir?
Does he work?
Yes, ma'am.
Okay.
Thank you, Judge.
Okay, and we're gonna do that on count 2, place you on pretrial release on count 2 as well.
Yes, ma'am. Thank you.
Thank you, sir. Good luck to
Does
you.
he, well, Your Honor, I didn't remember, does he work or go to school?
Defense?
Judge, I'm sorry, I didn't hear.
Wait, we're not done.
I'm sorry, I didn't hear the state.
Does he work or go to school?
Let me ask.
It says unemployed on here.
Judge does the Florida Barber Academy, and he also works with his grandfather at the roofing company, so he does both.
I just recently stopped working at Subway. I have 3 pay stubs.
Okay, that's gonna be the court's order. We'll go to the next case.
Your Honor, the North Broward Detention Center just called. They're wondering if you could take a case out of turn. Robin Criscione.
North Broward.
Yeah, he's like third from the end of the docket.
I have it. I had a medical reset, no problem.
Yeah, it was a medical reset the last couple of days, but he's able to attend today. There he is.
Okay, are you Robin Carmen Criscione?
Yes, ma'am.
Okay, sir, the court does find probable cause. You're charged with count 1, possession of morphine, count 2, possession of oxycodone, which is also known as Percocet, possession of alprazolam, which is also known as Xanax, count 4, possession of cannabis, 20 grams or less, count 5, again, another possession of Xanax, Count 6, possession of cocaine. Count 7, possession of heroin. And count 8, habeas for a felony. You have a status hearing on January 8th, sir, on that case at 8:45 a.m. in division, is that FJ?
How do I have 2 charges in Xanax? I don't understand. How
Okay,
does
sir,
that work?
sir, don't talk about the facts of your case. We have the public defender here in the courtroom that's gonna
Well,
represent you,
I'm
okay?
sorry, I was just.
I understand. State?
I see your paperwork, please. Your Honor, frankly, I don't have a PC anymore, so.
Well, I have it. Want it?
It would appear, Your Honor, and I'm looking at how they were identified, that they have 2 different imprints. So while they were both identified as alprazolam, it would appear that there was 28
Yeah, there's
units.
28 units in 2 pieces, yes. Okay, all right, so what's your recommendation?
In light of the no bond hold, Your Honor, I'd ask that the standard bonds be kept in place.
Okay. Defense?
Yes, Mr. Quisione is going to have to go in front of his division judge on the 8th judge. There's a no bond hold, so
Yeah, that's
he can
not
resolve
clear.
those matters there.
Okay. All right, so sir, on count 1 through 3, the court's gonna set bond at $1,000 each count. Count 4, $100, and counts 5, 6, and 7, the court is gonna set bond at $1,000 on each count. And you're gonna be held no bond, sir, on your capious felony. You're gonna go before Judge Shear, Division FJ, on January 8th at 8:45. Good luck to you, sir. Okay?
Fine, thank you.
You're welcome. Good luck to you. Okay, next one is gonna be, you're welcome, LeBrant Ramon Gray. Is there LeBrant Ramon Gray?
Yeah, it's just,
What is this one? Where is he? I don't see him.
he's on his way.
Major. Good morning, Judge.
Good morning. You're LeBrant Ramon Gray, sir?
Yes, ma'am.
Okay, is this another one of the co-defendants?
It is, Your Honor.
Thank you. Okay, state.
Well, my concern is, Your Honor, is he's got an open possession of cannabis case. I know. He was first put into the MDP program, and he was unsuccessful in that and kicked out of that. He then got transferred to Judge Zeller in drug court, and that's where his case is now when this allegedly occurred.
Okay. Okay, sir, the court's gonna find probable cause. You're charged with count 1, burglary of an unoccupied conveyance unarmed, and count 2, petty theft, 2nd degree, first offense. Your recommendation?
$1,000 bond, Your Honor, and the same release conditions as his other co-defendants. No contact with the alleged victim, no contact with co-defendants.
Okay, defense?
If I can have 1 second, Judge.
Sure.
Okay. How was your...
Judge, he has no objection to, I would ask that he be ROR'd if he's gonna be placed on pretrial release. They're gonna be watching him. So I would ask for an ROR. If the court's not inclined to that, he would be amenable to, accepting the $1,000 bond with pretrial release.
And Your Honor, just so the court knows, the reason we did not make a recommendation is because we saw that the defendant was already being supervised, and has already demonstrated his inability, for want of a better word, to comply.
And that's why I didn't make the recommendation, because he already got kicked out of one program because he was unsuccessful. He couldn't complete that.
So you think we should just set a bond and not pretrial release?
That's what, if the court, I'm asking for a bond. If the court wants to put bond in pretrial, that's obviously in the court's discretion, but, he's
Okay.
shown that he just can't follow the, conditions.
Okay, this is what the court's,
I'm sorry,
ahead.
just so the court knows that he's 19 years old, that he's single. He works for BurgerFi at the airport, so he had to get some kind of clearance to actually work at the airport. So it tells me that he probably doesn't have a record. I don't think there's anything there, but he had to get clearance in order to work there. He has no money in the bank, but he does have family members that work here. I mean, I'm sorry, family members that live here. I apologize.
Okay. Okay, this is what the court's gonna do. The court's going to, set a $100 bond on count 1 and set a $100 bond on count 2. The court also is gonna place him on standard pretrial release on count 1 and 2, Patrice. And there's to be no contact, direct or indirect, with the victim in this case, and there's to be no contact with the co-defendants. Do you understand that, sir?
Yes, ma'am.
Okay. And also, sir, how many times does he have to report?
He's gonna report 2 times a week in person.
I go to court at least once a month.
2 times
Once a week by phone.
and once a week in person.
Okay, sir, you're gonna have to report 2 times per, I'm sorry, not report, you're gonna have to call in 2 times per week. And you're also gonna have to report 1 time per month per week in person. Do you understand that?
Yes, ma'am.
Okay, that's it for now. Thank you, sir. Good luck to you.
Thank you, Judge.
Okay, next one's gonna be Tristan Zare Lawrence, and after that, Christian Lee Fletcher. Say that again?
I believe Lawrence's bond was supposed to turn.
Is there a Tristan Zare Lawrence?
Judge, I hadn't. 1 second. I had no response when I called him earlier.
Okay, let me go to Paul Ryan. Is there a?
He bonded.
He did, okay. All right, next one's gonna be Christian Lee Fletcher, and after that, James Norman Freiberger. Okay, Mr. Fletcher, the court does find probable cause. You're charged with petty theft, 2nd degree, 3rd subsequent offense. I heard something about his family's bonded him out on the $750.
Judge, yeah, he apparently contacted them and they're trying to postpone. I was just asked that the bond be left at $750.
State, do you agree?
That's fine, Judge.
Okay, $750 it is. Thank you very much, sir. Good luck to you.
Thank you, Judge.
Okay, his bond has been posted, tell him.
Has been posted.
Okay, James Norman Freiberger.
Good morning.
And then good morning, and then after that, we're gonna have Aaron Gardner Eugene. Okay, Mr. Freiberger, the court does find probable cause. You charge with count 1, petty theft, 2nd degree, 3rd subsequent offense. Count 2, false ID given to a Leo. Count 3, resisting an officer or obstructing without violence. And 4 is attaching a registration license plate not assigned. And count 5 is driving while license is suspended, 1st offense. State?
Your Honor, I'm going to be asking for a bond increase to $2,500. Mr. Freiberger currently has 2 outstanding warrants from 2017 from other states. One for that was issued for failure to appear November 25th for theft of a firearm, and
Where's that out of?
I believe it's in Delaware, out of Delaware, Your Honor.
Okay.
I'm also showing a warrant from March 20th of this year for failure to appear March 20th of this year, same state, for acquiring or attempting to or obtaining possession of a controlled substance by theft, forgery, 2nd degree, providing false statement to law enforcement with intent to delay, hinder investigation of a felony theft. Let's see. He has out of the state of Delaware. I apologize for the delay on, there's a lot here that I need to
That's
get
okay.
through. Okay, out of the state of Delaware, 2014, stalking.
Brian, I'm gonna need a photo order also.
You know what? Photo?
Do you have notes on him, like already written down that might make this a little quicker? Freiberger? Because I'm
Need a
having to
photo order
scroll.
in this case?
I do, Judge. He has scratches on his face. He said that he obtained during the arrest.
Okay, the court will grant a photo order.
Thank you, Judge.
Mr. Farberick, I don't see a permanent address on this booking report, so maybe you can obtain one for us.
Yeah, I already told the judge about those 2 warrants. I'm looking for actual priors he was resolved.
Judge, he indicated that his address is 103 Southwest 5th Avenue, apartment 1A, and that's in Dania Beach.
Burglary.
And what's the zip code?
That he's unsure of.
Okay, do you know, can you inquire into the length of residence?
He's been a resident there 1 month before that.
Is that owned or rented?
He rents.
Okay, so it would appear really no ties to South Florida. Burglary out of Delaware in 2003. Theft, 2003 out of Delaware. Criminal mischief, 2003 out of Delaware. These are all out of Delaware. Just make that easy. Burglary, 2002. Burglary, 2002. Burglary, 2002. Receiving stolen property over $1,000, 2002.
While the state's looking up the rest, I can indicate to the court that he's actually lived in Florida for 7 years. He was living in Monroe County before he moved up here a month ago. He is single. He has grown children. He just got a job working for Nissan. He has no money in the bank. Even if the court were to leave the bond at $750, which is where it's currently set at, he indicated that he wouldn't be able to afford that, and he would lose everything. He would lose his house. He's going to lose his car. Everything that he owns would be gone. He wouldn't be able to post any kind of bond. So I just want the court to be aware of that when it makes its determination to set bond.
This entire time, I just want the court to have an idea of how many prior arrests he has out of the state of Delaware. I've been literally scrolling through all of them. There's no reason to have any confidence that Mr. Freiberger, of his own volition, will appear back in court on this case with the 2 active warrants. He has a history. I mean, I've only provided the court with the convictions. I won't get into how many arrests he's had out of Delaware. And in this case, he's knowingly stealing a tag from a vehicle, and which is reasonable at this point to avoid detection, knowing that he's got 2 warrants out of the state of Delaware.
Okay.
And gave a false ID.
Okay, this is what the court's gonna do. The court's gonna set bond on count 1 at 1,000 and leave the other ones in place. Good luck to you, sir. Next one is Aaron Gardner Eugene, and after that is Jerome Mikel Sanchez. Okay, sir, can you please state your name?
What's your name?
My name is Aaron Gardner, Eugene.
Judge, he indicated that he has a private attorney. Her first name is Lori. I don't.
No, his first.
Oh, I'm sorry. His first name is Lori. I'm not sure who it is, but he indicated that he has private counsel.
Do you have their number, sir?
No, but my mom does.
Okay. Maybe the public defender's office can assist and call his mother?
You want me to give it to him, or?
Yeah.
All right.
Does not appear to be a notice of appearance filed on Mr. Gardner Eugene's case.
Well, my suspicion is that whoever was representing was representing when it was a juvenile matter.
That may be.
And this is now a direct file, so there might not have been any type of agreement as to the.
That could very well be too, but
Do you have a name at least? In the,
no, there's no attorney listed, Judge. Maybe Mr.
No, for the
Forbera can
juvenile
find out.
case?
Hmm?
For the juvenile?
I can't bring that up.
Okay.
Yeah, I know.
Did Mr. Farberick go to call your mother, sir? Did Mr. Farberick, the attorney that was standing there, go to call your mother? Okay.
Yeah, he's on the phone with my mother right now.
Okay, thank you. You can mute it again. Thanks.
All right, apologize.
It's okay. Out that carpet. Thank you. He's the best.
Your Honor, just to let you know, the next case, I didn't realize, is actually it's a domestic.
Violence or one to Judge Cohen?
One to Judge Cohen. It's a felony domestic violence. Yeah, I didn't realize until now.
Okay, sir, why don't you have a seat? Just have a seat right there. We're gonna call another case, yeah.
No.
Is there a Jerron Mikel Sanchez? Okay, Mr. Sanchez, your case is supposed to be heard before Judge Cohen this morning. I don't know why they put you in for magistrate court.
It's because when it was filed, it wasn't assigned to Judge Cohen.
I see.
But it is a domestic violence case. I'm looking at the allegations and,
Okay, well, it's
matter of fact, if you look at the
11:44. Can someone call Judge Cohen's office?
you'll have to see him tomorrow morning.
Okay. All right, sir, unfortunately, we're gonna have to reset your case for tomorrow morning, 12/29/17. You wanna make sure Judge Cohen's in all week?
My understanding, I mean, I'll check, but I
Can we
haven't
find
heard.
out?
Well, let me put it this way, Judge. If he wasn't gonna be here Friday, tomorrow,
gonna be here.
we would have been getting the cases and
Okay, so sir,
pre-trial's
tomorrow
gonna be
morning, make sure they bring you before Judge Cohen. Madam Clerk, can we do some type of, note with the clerk's office or someone? Okay, thank you.
Do you have the PC there?
Okay, and then we're gonna have Tony Jerome Davis and then
Have to
Dennis
live together
Michael Cleary.
if they're involved in a relationship at the time.
Okay, why don't we go and see, where is Tony Jerome Davis? Is he somewhere else? And Mr. Reedy, you can handle this?
Yes, Judge, he's gonna be a medical reset.
Okay, so this is a medical reset. Did you get that pretrial?
Yes, Your Honor.
Okay, and then the one after that is going to be Dennis Michael Cleary. Okay, let's go to North Broward. Okay, Dennis Michael Cleary?
Yes, may I say something before, at the end of this?
I wouldn't.
Your Honor.
You can say something, but we're telling you not to talk about the facts of
Okay,
your
but
case.
I won't talk about the facts.
Okay, if you want, you can actually speak to Mr. Reedy. Can you speak to him and find out?
Mr. Cleary has literally, I don't know how many no bond holds on him right now, Judge. His attorney is Pascal Chauncey. I'll let her know that he is currently being held, but there really isn't very much I can do to help Mr. Cleary today.
I'm
He's
not
just,
asking for your help, sir. I'd like to make a statement at the end of this proceeding, that's all.
Your Honor, just if I could provide the court some information, and this is one of the change of charge cases I provided the court paperwork to.
So should we call his attorney and call him back here at 1:30?
Does he have the public defender?
I don't know what her schedule is, Judge.
Does he have the public defender or is it a private attorney?
There's a public defender.
Yeah, then I mean, we have a representative public defender.
Okay, I understand.
Your Honor, when Mr. Cleary was first arrested, he was charged with aggravated battery, and criminal mischief. We're just here on the battery, which has been upfiled to battery with the hate crime enhancement. And his bond was originally set at $5,000. Even with the enhancement, and even though he faces more serious consequences on this now, I'm asking that the court keep the $5,000 bond, reset it back at $5,000, noting that.
Well, right now, it's not set at anything.
It was originally set at $5,000. I'm asking
Okay.
the court to place the $5,000 bond back on it, noting, as Mr. Reedy also already said, Mr. Cleary has multiple no bond holds, and I believe those are out of Judge Porth's division as well.
Okay.
Yes.
Well, it says Judge Siegel.
The additional charges?
Charge 2.
No, Your Honor, well, I see Judge, yes, but what I'm saying is he has additional no bond holds that aren't before the court. Those have been transferred those are before Judge Porth. I imagine this will probably end up following.
Okay.
And
So, sir, Mr. Cleary, the court is going to find probable cause. You're charged with, is this an ad charge state?
no, it's a change of charge, Your Honor. He was-
Okay, a change of charge for touch or strike battery, sir. Right now, the bond is set at 0. So state, you're recommending 5,000, you said?
I'm just asking for the $5,000 bond to be placed back
That's-
on that charge.
Okay. And defense?
Mr. Cleary, would you like to address the court prior to the court setting bond on this matter?
No, I wouldn't. I would just ask the court to place me in the life skills program, if possible.
Yeah, I'll ask the court to do that. Would you consider signing an order, placing him in? Do you need an order to go into life skills?
Yes. Yes, they told me I need one.
All right, I'll ask the court to draw, if the court's willing to do it, I'll draft the order.
I just know that there's been issues with that in the past.
All right, so let's just do it. And if they don't do it,
Yeah, no, I'm fine.
then there's nothing I can do. If it has to be in connection with the sentence.
No, I'm completely fine with that.
Is that okay, Ms. Patrice? Okay, all right, so, as to the touch or strike battery, the court is gonna set bond, sir, at $5,000 and find probable cause for count 2. And the court also is gonna order, your entry into life skills. The jail might not wanna do that because there might be a condition with them that you have to, be sentenced in order to be in life skills in the jail.
No, that's
Okay.
not true.
How about if I put it as a recommendation from the court?
Because if there's space, because some people who are actually awarded.
I understand. Okay, so, sir, the court's gonna sign an order recommending that you be placed into life skills. How about that? Okay?
Thank you.
You're welcome, sir. Good luck to you. Okay, let's go back to the main jail. What are those right there? That's for later on, right? Okay, good. Okay, Aaron Gardner Eugene.
Judge, I was able to speak to his mother. His mother indicated that they have retained counsel. The counsel's name is Mark Lowry. She gave me Mr. Lowry's phone number and indicated he was out of town today. I did contact Mr. Lowry. He indicated he would be back on Friday evening. Currently, this case, because it's set for a hearing, he's unable to bond out. What I would be asking the court, and I spoke to Mr. Lowry about that, is if the court would set a bond for him, if it's, you know, if it needs to be tweaked or whatever, that they can do that later on. I can tell the court just in my brief conversation that Mr. Gardner's lived here all of his life. I can also tell the court that his mom can afford, you know, something but not a lot of money. What I would be asking if the court would consider a bond somewhere in the neighborhood of about $1,500, and that way she should be able to hopefully post that.
Okay, sir, the court's gonna find probable cause. You're charged with 1 count of robbery by sudden snatching without a firearm or weapon. State.
Your Honor, he has no record. I was gonna be, in light of the fact that this is a robbery, I was gonna be asking the court to set a $2,500 bond. And an order of no victim contact, and the alleged victim's name is Edgar Reyes.
Okay, anything further, defense?
No, Your Honor.
Okay, the court's gonna set the bond at $2,500. And sir, you are to have no victim contact, direct or indirect, social media, texting, anything of the like, with an Edgar Reyes. Do you understand that, sir?
Yes, ma'am.
And you're also, sir, not to be on the online sales site OfferUp. Do you understand, sir?
Yes, ma'am.
Okay, thank you very much.
All right.
Good luck to you. You're welcome. Okay, are we doing these change of charges, or did we do them all?
I think the only one we had was Davis, that was a med reset.
Okay, Tony Jerome Davis is a medical reset.
I believe so. If you want, Judge, maybe, if you want to give the paperwork I
What
gave,
about Dennis Cleary?
that was the battery. Your Honor, you might want to give the paperwork I gave you on Davis to the clerk so it could just be attached to the reset
Sure, no
paperwork.
problem. Okay, let's just go through. I think, Mr. Farbarek, we're done at the main jail.
Okay, yes, we are.
Okay,
What time are we starting this afternoon?
1:30, sir.
Perfect. Thank you
Okay,
very
and
much,
just to
Judge.
let you know, we are gonna do the juveniles around that time. They're supposed to be here around 1:15.
Okay.
I'd like you to be here at 1:30 if you can, because I don't know how many juveniles, and they could have one, and I want to be able to start right away. Okay?
See you folks at 1:30, Madam
Okay,
Clerk. You
hold
have a
on,
lovely evening.
Mr. Ready? Mr. Reedy?
Yes, ma'am.
Hold on, I just want to go through the jail and check. Yesterday, we had a couple people. Anybody at Paul Ryan? Nobody? Anybody at Conti? Nobody? Anybody at North Broward?
Looks like we're all good.
Okay, so
All
Mr.
right.
Barbarick, we'll see you back at 1:30. Thank you.
Great, thank you, Judge.
Court's in recess.